Morning, Lordship.
Yes, yes. Morning.
From the Delhi code list, under the heading for orders with defect, item 1, civil review number 42 of 2020, Mr. Ravi Prakash Mishra for the petition.
Your Lordship, I am for the petitioner, Your Lordship. I pray for 2 weeks' time, Your Lordship.
2 weeks' time, peremptory to remove the following surviving defects. Office to place the file. Mr. Gaurav Raj.
Item 2, first appeal number 8 of 2022, Mr. S.P. Das for the appellant.
In this matter, Lordship, I am praying for 3 weeks' time to be given to us to remove the defect.
3 weeks peremptory to remove the following defects. Office to place the file.
Item 3, WPT number 872 of 2022, Mr. Prem Madi for the petitioner, Mr. Ashok Kumar Yadav, Mr. Prashant Pullo for the respondent.
Lordship, we are appearing on behalf of the respondent.
Your Lordship,
Yes, Mr. Martin.
as far as Your Lordship, many defects has been cleared.
There are 2 defects, 1 and 2.
One is court fee also.
Oh, remove them within 1 week or 2 weeks.
Court fee yesterday I have paid, Your Lordship.
Okay.
I have paid.
So you have filed court fee.
Court fee I have paid, Your Lordship.
You appear to be unsure.
Just check
Your
it.
Lordship, I
2 weeks' time to remove the following surviving defects. Peremptory, office to place the file.
Item 4, WPT number 1378 of 2022, Mr. Nitin Kumar Prasad.
If it may please your Lordship.
Yes.
If your Lordship will turn to page number 29, your Lordship.
Page number 29 to 37 are not fairly legible. There are the
Yes, your
same
Lordship. Your
petition,
Lordship.
same issue, different financial assessment years. What is
Yes, your Lordship, same petitioner, these matters may be tagged. And so far as defect number 2 is concerned, these are the screenshots of the previous communications, your Lordship.
27 to 29. 29 to 37. This is what? This page 29 is part of order.
Assessment order, your Lordship.
So,
The previous communications which have been done, these are the screenshots, your Lordship. So I was praying these pages may be
if
ignored.
the assessment order contains such illegible extracts, how will we appreciate what the assessing officer wants to convey through these extracts?
So what happens is that whenever any show cause is issued and we file our objection, what the assessing officer does, the exact extract of or the submission is taken as a screenshot and is put in the order. So that is the same thing, Manoj.
You need to give the enlarged copy of the screenshots.
Manoj, we tried it, but it's coming very blurred. It's
No.
completely blurred. So
If you know the contents, you can get it typed and file it by way of a separate.
Because it appears at page 33, there are question answer.
although that is not in dispute because the issue is not with regard to the assessment order, a point of law, because the assessment order nobody is disputing.
No, so there are same defects in other writ petitions
All the cases
also.
same defects, Manoj. All the cases same defect.
In item 8, there is one more defect, 2 and 3. 8 में क्या है?
Item number 8 is Subisha Enterprises 1407. No, it's the same defect. It's the same defect.
अच्छा उसमें थोड़ा ज़्यादा है 33 to 37 तक है
जी.
Nothing hinges upon these extracts.
No, nothing, Manoj, nothing.
One thing can be done, sir, at the timing, for the timing it can be ignored. And
Yes,
if
yes.
they will rely on any part, then they will supply the type copy at that.
Yes. May I only indicate minutes? Whatever
Yes.
we have challenged is after the assessment order we have accepted.
No, but whatever it is, once we apply ourselves to the merits of the case, in case there is any connection with the findings of the assessing officer, then
Minutes, what we will do, let it be ignored for the time being. I will try my level best to get it typed within this 2-3 days holidays. I'll try to get it typed.
Samrita Sinha, you also try to get the proper enlarged copy of the extracts quoted in the assessment order.
I will be, Your Lordship. Enlarge, we need to get it typed, Your Lordship, because enlarge must not be there, but we need to get it typed. I will try to get it typed, Your Lordship,
Yes.
if possible.
Let WPT 5 to serial 8, serial 5 to serial 8 be also tagged with the instant writ petition, item 4, since all of them raise the common issues and concerning the same parties. And
There are two petitioners, minutes.
Acha. Sudesha Enterprise, acha.
Sudisha
Since
Foundry and
common
Sudisha
issues are
Enterprise.
involved,
Yes,
common issues are involved relating to
interpretation of section 270 AA.
interpretation of section 270 AA within bracket 1 of AA of the Income Tax 1961. Stop. Then counsel for the petitioner, Mr. Nitin Kumar Pusari, submits that the surviving defects in all these writ petitions relate to certain extracts of certain screenshots extracted in the assessment order, which may be ignored for the time being, as the legal issue raised in these writ petitions do not hinge upon the relevant extracts quoted in the assessment order. Stop. He, however, submits that in case it is needed, the writ petitioners would endeavor to supply it at the time of hearing. Stop. Accordingly, the surviving defects are ignored. Stop. Learned counsel for the Income Tax Department, Ms. Amrita Sinha, also submits that she would try to take the proper legible copies of the extracts quoted in the assessment order from the department for the convenience of the court. Stop. Let the matter be listed under the heading for admission.
It's on a physical day, if I can request, minutes.
On any physical day.
Much obliged. Much obliged.
Item 9, first appeal number 351 of 2017 for orders. Mr. Lukesh Kumar for the appellant, Mr. Pandey A.N. Rai for the respondent.
Somebody was to file, the respondents were to file reply.
I am appearing on behalf of respondent number 1, 2, and 3, Your Lordship. I pray for 3 weeks' time for filing the counter affidavit.
This is an admitted matter. IA has been filed for custody.
Custody of the child.
Yes, sir. Yes,
3
Lordship.
weeks more time by way of last indulgence is allowed. 2 weeks more time by way of last indulgence is allowed to the learned counsel for respondents to file reply to IA number 2482 of 2021. Listed after 2 weeks.
Much obliged, Your Lordship.
Item 10, LP number 341 of 2021, Mr. Rahul Dev for the appellant, Mr. Rajiv Sinha, Mr. Juan Kashyap for the respondent.
Yes.
Lordship,
Yes, sir.
Your Lordship, in this matter, Mr. Biswajit Das will be arguing the matter.
Here the service is not.
Service report has not been received for RBI, the respondent number 2.
My Lord, may I submit not in this regard? I have already intimated to the RBI counsel who appeared before the Honorable Single Judge Bench, and he only today morning intimated to me, to us, to my colleagues, that he has not been appointed by the RBI as yet, though he has already intimated the RBI. So he is not unaware as to whether he is appearing or not. Any, my lords, my relief today, which I am seeking before my lord, is my interim stay, which was recorded in the last order dated 28th of March 2022. For a moment, your lordship may kindly peruse that order.
The, no, the point is that notices have been issued
Yes,
and there is no report of service of notice. So,
my lords, on the last occasion, on 28th, both the respond number 1 and respond number 3, they appeared. Only the respond number 2, which is the RBI, which did not appear on that day, I have already served him, and he already communicated to us the counsel who appeared in this before the single bench. Now, as far as my relief today, which I am seeking before my lord, is where the respond number 3. It has nothing to do with that of the respond number 1 and 2 for the time being. My substantial challenge of the RBI circular, my lords, of COVID-19 guidelines is against, of course, the respond 2, which I think, my lords, can be taken up later on, because my interim relief is not hinges on that. In the absence of the respond 2 will not, my lords, impact your lordship's order on the interim applications. It's a very limited relief, lords, for the time being. I was granted that protection before the single bench on 11th of November 2020. I am only seeking a similar relief, lords, which already recorded in the order dated 28th of March. If your lordship can just for a moment see that particular order.
why this has come before us? This is a DB1 matter.
Yes, ballots. But the absence of the DB ballots caused me to mention before the Honorable DB3 on 28th. And
So, therefore, it was on that particular day that DB1 could not hear it,
correct.
and the matter was, to be taken up as per the administrative notice by the concerned DB3.
Correct, ballots.
DB2 doesn't come in picture.
Right.
The office seems to have wrongly placed it before this division bench. It should have placed it before the division bench number 1, because there is no order of recusal either. We don't have an LPA roster at the present.
Your lordship may kindly peruse your lordship's own order, that is on the 7th of April 2022, when I appeared before my lord through a VC, though I was in the Ranchi then, my lords. Your lordship has directed to post it the matter on the 30th of April, that is today. And because of the urgency, my lords, this matter has to be taken up, which I requested your lordships on that day. And today, I was told that
Mr. Counsel, maybe it might have been inadvertently listed before us in the previous week, but there is no order as such, fortunately, by which we have ordered to list it today. It may have been passed over.
My lord, may I clarify, my lords?
Yes.
I was given to understand, though I am not from that particular High Court, your lordship is absolutely right. But just for the sake of my satisfaction, my lords, on 28th, when your lordship's DB1 and DB2 was absent, it was posted before the DB3. Now the DB3 has passed an order and posted this matter on 7th for a consideration of my interim application.
Yes.
Even on the 7th, my lords, when the DB1 was not there, as per the administrative order, my lords, this matter was posted, obviously by virtue of, my lords, the master roster, the Chief Justice's, Honorable Chief Justice's direction. This matter was posted before my lord on DB2 on 7th. Now on 7th, because your lordships were sitting separately, this matter was posted to be heard on 13th, that is on the VC day. That is today is the VC day. Because I was, so therefore on today, the DB1 also is absent, my lords. And in view of the administrative order, it has to come before my lord. So therefore, my lords, according to my humble submission, your lordship can hear this matter, and it is as per the judicial order. My lord is not impeded. My lord is having no impediment, my lords, to hear this matter on judicial side.
No, Mr. Sujit, we appreciate what you are trying to say, but since it's a kind of a regular affair of a bench not being there and the other bench having to take it up, We are just trying to check facts.
My lords.
तिवारी जी, ये आज क्या DB1 नहीं है क्या?
है लॉर्डशिप।
है
जी।
अच्छा, ये अपील में कोई असाइनमेंट का ऑर्डर तो है नहीं?
नहीं लॉर्डशिप, डाटा बैंक में था तो उसी से लगता है कि आया है, पता कर रहे हैं हम डाटा बैंक
हाँ,
से।
नहीं तो ऑफिस की गलती है। DB3 का ऑर्डर फिर DB2 में क्यों प्लेस करेगा? दूसरी बात, तीसरी बात कि ये लास्ट वीक में हम लोग के बेंच में था क्या?
Was mentioned before your lordship.
Perhaps your lordship, may I submit? It was before DB1, your lordship, but DB1 was not holding
No,
court, so we
that we
mentioned it
understand.
before.
Perhaps
Yes.
you made a request. We said that you can mention it on any particular day or what.
Yes. Your lordship
Was
has
there
been
any-
pleased
was
on
there
7
any-
to place it for today, but admittedly, I guess it has been placed before your lordship. It must have been placed
that's
before
true.
DB1.
But
There is no such order of assignment also.
Honorable DB1 was not available. There was a notice that the cases of DB1 will be mentioned before your lordships. Then it was mentioned before your lordships. Your lordships were not inclined to hear the matters which were not listed before your lordship, but passed an order that this case be fixed on this day today, and with a liberty to the appellant to mention it before the concerned court.
No. That's not the correct. May I, my lords?
That is the correct, my lord. That is what has happened.
No, Mr. Vishwajit, there is no confusion about that because we are well conversant about the practice being followed here. Perhaps because of your urgency in the matter, you are trying to insist upon us to take it up, but this is not assigned to us.
I know, my lords. I appreciate. I was given to
And
understand that.
had there been a notice today due to non-availability of DB1, for us to take it up, we would have been glad to take it up. But
Okay.
otherwise, it would be without jurisdiction.
My lord, my lord. That means, is it that the honourable court is suggesting, my lord, that DB1 is not sitting today?
No. I just checked up. DB1 is sitting today. So
Oh.
this matter
Yes.
lying in the roster of DB1
Yes.
ought to be taken up by that DB1.
Oh yes, my lords. Your lordship is absolutely right. My apology, my lords, to that extent. I was given the wrong fact then.
Now Mr. Rahul Dev also realizes that it is to be listed before DB1. We did pass an order, gave you a liberty for urgent mentioning also the last date when you mentioned it before our bench. But today we do not have any assignment or authority to take it up.
My lord,
We
then
can only say today, Mr. Biswajit, that the office has wrongly listed it before us, though the appropriate bench having the roster of the latest patent appeal is available today. And then whatever date you ask for, whether on the Monday itself we can post it.
my lord, may I then request, my lord, since the matter is posted on the judicial side today and there is an error on the part of the registry, my lords, may I then request your lordships may kindly put up before the appropriate bench at 2:15 p.m., my lords?
That it is that liberty we do not take with the Chief Justice's court
Oh,
because
I'm so sorry, my lords. Then, my lord, I understand, my lord. Then, my lord, I am before my lord's hand. As long as my learned friend appearing on behalf of the respondent three is not taking coercive action, I have no problem to bother your lordships. That's my only one.
that is between you and him. Both of you are on the screen. We do not lend ears to whatever goes in your private discussion.
No, my lords, I only say that your lordship may kindly then put up before my lords on Monday on 18th.
Very well. The matter has wrongly been listed today.
Achha, my lords, I was given to understand that the Honorable Chief Justice bench is sitting at 2 p.m. Sitting
So
today.
you can make a mention before Honorable Chief Justice. That is your liberty, as you mentioned it before us on the previous day.
My
If the
lords.
office has done a mistake and the Honorable Chief Justice feels, that division bench feels that yes, because of your mentioning an urgency, it should be listed before that bench today itself, it is up to that bench to get it, to be taken, to be...
My lord, on 18th, then my lord, on 18th is a physical or virtual?
It's a physical day.
Then my lord may kindly post it on 18th then, my lord.
18th is a physical day, 19th is a physical day, 20th would be perhaps, as per the present arrangement, that would be a virtual day.
Then my lords may kindly post it for 20th then.
It appears, please send your appearances, Mr. Rahul Dev and the other side, counsel.
Your lordship.
It appears that the matter has wrongly been listed today, though neither it is assigned nor the roster of letters patent appeal. हम लोग के यहाँ तो LPA नहीं है ना तिवारी जी, nor the roster of LPA is allotted to this bench. Stop. Let the matter be listed. Learned counsel for the petitioner, appellant, Mr. Biswajit Das, submits that on the previous date, due to non-availability of the division bench number 1, the matter was mentioned on mention was taken up on urgent mentioning by this bench and ordered to be listed today. Earlier date 7th April. Be that as it may, office to see. He prays that the matter may be, in that case, the matter may be listed before the appropriate bench on 20th.
No, my lords, may I request, my lords, sorry. Then, my lord, I was told that 18th is a better date, my lords. I may travel to the Ranchi, my lords. I'll take the charge.
You will come to Ranchi?
Yes, my lords, I'll take the charge.
On 18th, but better you come on 19th. Don't take chance 18th.
I have some assignments in Supreme Court, my lords.
Okay, very well.
Unless your lordship suggests me that 18th is really problematic.
No, just by way of abundant precaution, I thought.
Then, my lord, on that day, if the DB1 will not be there, then I'll definitely praise for my lords. As per the roster, my lords.
He prays that the matter may come up on 18th April 2021 before the appropriate bench. Stop. Office to take steps and list the matter before the appropriate bench.
For press filing.
On 18th.
For press filing.
18th April 2022, if possible.
So much obliged.
Much obliged.
Item 11, WPT number 4686 of 2021, Mr. Nitin Kumar Prasadi for the petitioner, Mr. Rahul Sabu.
This is virus matters?
Yes.
Yes, your lordship. This may be tagged with WPT number 1143, your lordship, of 21.
1143?
Yes, your lordship, of 2021.
And which was the last case in which we passed similar order on Monday, perhaps?
Your lordship, it was Phenolex cables. I'll provide the number, your lordship.
Phenolex में जो order pass किए थे ना परसों शायद, वही order इसमें कर दीजिएगा.
I'll provide that case number, your lordship.
16(4) of the JGST Act and Rule 61(5) by amendment dated so and so. List same order रहेगा. List it along with so and so before the appropriate bench.
Much obliged, your lordship.
Yes.
Item 12, WPT number 5429 of 2021, Mr. Piyush Poddar for the petitioner, Mr. Ashok Kumar Yadav for the respondent.
Yes, my lord. I am going to the petitioner, my lord. The virus of the Amendment Act, Electricity Duty Amendment Act 2021 has been challenged, my lord.
Right.
And the Honorable Court number 1 is hearing the batch of read petitions, my lord. And on the similar issue, my lord.
So, what is the number of the batch of writ petitions?
The lead case is WPT number 3228 of 2021, my lord.
Since the virus of Section 2 and 3 of the Jharkhand Electricity Duty within bracket Amendment Act 2021 is under challenge, let the matter be listed before the appropriate bench as per the present distribution of roster. Stop. Learned counsel for the petitioner, Mr. Deepak Kumar Sinha, submits that the similar writ petitions involving similar issues, same issues are posted, are being taken up, are pending before the learned division bench number 1, such as WPT number 3228 of 2021. Office to take note of.
Obliged, my lord.
Item 30, WPT number 779 of 2022, Mr. Saket Upadhyay for the petitioner, Mr. Amit and Mr. Piyush for the respondent.
This is service tax on royalty.
Service tax on royalties.
services tax and royalty, my lord. The demand has been made, my lord. The lead case is the entry order, your lordship, has been placed, has been marked as annexure 6 to the petition, my lord. The lead case is, my lord, WPT number 3878 of 2020, your lordship. And recently, my lord, in the month of January, my lord, similar order was passed in WPT number 4519 of 2021, your lordship, on 10th of January
So why
2022, your
why
lordship.
didn't you send this short order? Yeah, that short order you can send वो जो service tax on royalty वाला जो
Yes.
वो उसी के basis पे इसको tag कर दीजिए.
Lordship. I've emailed it just few months back, my lord. I apologize for the delay, my lord. I've emailed it, my lord.
Counsel for respondent CGST हैं सिर्फ इसमें, Mr.
Yes, my lord, I am.
Pati.
Yes, my lord.
Let the name of Mr. P.S. Pati appear on the list. हाँ, अच्छा, ओके. नहीं, अमित कुमार जी का भी नाम है. वही शॉर्ट ऑर्डर से टैग कर दीजिए. हाँ, वही इंट्रीम ऑर्डर. सेम जो एनेक्सर 6 का जो एंट्रीम ऑर्डर एक्सट्रैक्ट किया हुआ है ना, वो शॉर्ट ऑर्डर में बस वही ऑर्डर है. और टैग कर दीजिए.
Most of the lordship.
3 weeks to you, Mr. Pati. Similar.
My lord.
Yes.
Item 40, WPT number 1438 of 2020, Mr. Manav Podar for the Ms. Amrita Sinha for the response.
Your Lordships, I was just making a small mention in this case, Your Lordship. There's one more writ petition of the same appellant for the similar issue pending before Your Honor. If the same can be clubbed and be fixed for the hearing on a physical date in the coming week, Your Lordship.
So that has not come on the list.
That has not come on the list today, Your Lordship, because there was a minute defect which has already been cleared last week, Your Lordship.
Okay, but let it go before a bench of which Abhish Kumar Singh Jay is not a member. Then you get that one also listed and it will go before another bench.
Okay,
Amrita Sinha for respondent department.
Obliged, Your Lordship.
For admission, item 15, WPS number 835 of 2018, Mrs. Banani Verma for the petition.
Read the matter also, same, before another bench.
Item 16, EA number 9 of 2019, Ms. Amrita Sinha for the appellant, Mr. Manish Mishra for the respondent.
Have you filed any IA or SA?
No, Your Lordship, for that I seek apology, Your Lordship. I am praying for 2 weeks further time. If I could not file, it was a mistake on my part, Your Lordship, so I just apology for that.
2 weeks more time is allowed to learn counsel for the appellant to comply with the order dated 10th March 2022. List it immediately thereafter.
Item 7, EA number 16 of 2019, Ms. Amrita Sinha for the appellant.
You would want to withdraw?
Yes, Your Lordship, I have already circulated the mail in this regard yesterday itself.
Same order of withdrawal and counsel for the appellant, Ms. Amrita Sinha seeks permission to withdraw this appeal on instructions since the tax effect of the disputed amount is less than the monetary limits prescribed for preferring an appeal before this court in terms of CBDT circular number 3 of 2018.
Yes, Your Lordship.
3 of 2018. Mr. Devesh Poddar. The email containing the written instructions we kept taken on record. He kept on record. Mr. Devesh Poddar appears for the respondent and does not object. In view of the prayer on behalf of the appellant, the appeal is dismissed as withdrawn.
Item 18, first appeal number 78 of 2020, Mr. Amitesh Kumar Jain for the appellant, Mr. Praveen Shankar Dayal for the respondent.
Mediation has failed.
Yes.
Mediation has failed as per the report of learned mediator Jhalsa bearing letter number 956 dated 26 March 2022. Admit call for the lower court reports in connection with so and so public. There is no delay.
There is no delay, my lords.
For the Appellant Mr. Mehta for the respondent Mr. Praveen Shankar Dayal. Anup Kumar Mehta.
Because I just wanted that one round because she appeared only once, my lord.
Pardon?
If your lordship could ask for another before your lordship, that would be fair. Because he's a scientist and she's also a bank officer. If your lordship can hold this in your chamber, my lord, where both the parties, the appellant is about 59 years, the respondent is about 56, 57 years old, my lord. An attempt can be made by your lordships in your lordship's chamber, my lord, or in open court.
Both are residents of Jharkhand.
They are both residing in the same house at Dhanbad.
Then why this was a physical mediation?
It was a physical mediation. And
why did your client not appear, Mr. Dayal?
Lordship, on one date she appeared, thereafter she could not come, Lordship. As I told your Lordship earlier also, because she is a patient of cancer, Lordship, suffering from cancer. Maybe because of that reason she could not come. Because it was very difficult for her to travel alone also from Dhanbad.
So we will not admit, then we will ask them to join the proceedings. They can join on a virtual day online instead of asking her to come. Will it serve the purpose or we should ask them to come physically?
She will come physically, Lordship.
I think both of them can appear with your lordship, my lord.
Mr. Dayal, your client can appear on any physical day.
Yes, Lordship, she will come.
लिखिए
Convince her to
as यहाँ लिखे थे failed जगह पे लिखिए as the respondent did not appear on the on the next date. Stop. Learn counsel for the admit का हटा दीजिए. Learn counsel for the appellant Mr. Mehta submits that considering the advanced, considering the age of the rival spouses and that the respondent is also suffering from a serious disease, it would be in the interest of parties if the parties to understand the benefits of an amicable settlement of their matrimonial dispute by calling them for ऐसे लिखिए then counsel for the appellant Mr. Mehta submits that both the parties, both the spouses are in the the appellant is 59 years old while the respondent is 56 years old. Stop. The respondent is also suffering from a serious disease. Stop. It would be proper if the parties may call to appear in person. Before this court in an endeavor to find out an amicable settlement of their long-standing matrimonial dispute. Stop. Then counsel for the respondent agrees to the proposal. Stop. Parties are ready to then counsel for both the parties submit that the parties would be willing to attend physically, appear physically before this court. Stop. Taking into consideration the request made by learned counsel for the parties, let the case appear on April 2022. Parties should remain present before this court. Will remain present on the set date physically.
Item 19, WPS 1787 of 2020, Ms. Leena Mukherjee for the petitioner, Mr. Gautam Rakesh, Mr. Mahesh Tiwari for the respondent.
Yes, my lord, in this case I am appearing on behalf of the petition. This case is, my lord, against the...
This is called, this was the only case, as you had pointed out, when we passed an order in favor of one of the applicants of that 1998 panel.
That is certainly another, that is another case. Another case, my lord.
So in that you had informed that there is one more case pending before this court concerning the same issue of alternative employment out of the panel of 1998. Now, we were very clear that we will not grant that benefit to any other person, and we made it clear in our order that it would not be treated as a precedent. So, our minds have been made open on that date itself.
Yes, to that extent, I may clarify that position, my lord. Yes, your lordship's observation is that will not be precedent, no further cases, only one case pending. But this case is not that type of case. That is a confusion. I want to remove that confusion. This case is for handicapped quota. 99.
This is not the case. This one is
No,
not
no.
that case.
No. That is not alternative quota. That is the appointment against the handicapped quota. The advertisement was made in the year 1999. Appointment letter was issued to so many persons in the year 2001, including the petitioner, but they was not allowed to join on alleging that eligible percentage of the disability is not up to the mark. The case, my lord, such cases are kindly consider the page 34. Only that, maybe that is not the case. Page 34.
Mr. Pallav, you want to interject?
Yes, my lord. One small submission. Probably rejoinder has also been filed, and the case has been entrusted only couple of 2 days, 3 days back to us, my lord. So I pray only not today, my lord. Let this matter come, because I have shared my feeling with my learned adversary, senior counsel. That this is the price. So a week's adjournment I will pray, my lord.
Yes, my lord. That is the thing. Yes, my lord. I have nothing to say. I may be accorded.
Pass over for the date.
My lord.
My lord, only the case is that only for the short out the case, my lord. Only the case is that it has been finally decided by the various high court, including the Jharkhand High Court, as also the learned cat. The disability commissioner's certificate will be absolute, which will be constituted under the Disability Act, and that on that basis, at least 20 to 21 persons has been given employment. This petitioner has been singled out as on the basis they rejected my claim on the basis of the certificate issued in the year 1993. That is before the Act has been came. Much obliged. Only short out the matter.
You just pass on that order of ours of January in which the other case which I was talking about has been decided that no, we could not.
Yes, madam. That is another case, madam.
So that confusion will be over.
Yes, madam. That is another case. That is for alternative appointment. They were appointed. They were selected for a particular post, but medically unfit. Then they were given alternative. I shall give that judgment.
Please send that judgment to the court master before the next date.
Yes. That is absolutely separate.
Very good.
Much obliged. I shall give.
Grateful.
To the other side also.
Yes.
Item 20, EA number 17 of 2021, Mr. Ramil Kumar for the appellant, Mr. Madhusudan Mittal, Mr. Salona Mittal for the respondent.
Lordship, in this case, I have circulated prayer for adjournment, Lordship. On the last occasion, Lordship has directed to file the relevant case laws with provision of law and also with the materials placed before the lower court, Lordship. I was only praying for further 2 weeks' time, I have asked the materials from the department, Lordship. Um, it has
2
not
weeks more time as prayed for is allowed to learn counsel for the applicant, Mr. Amit Kumar, to file the, to submit the compilation
supplementary by way of
and
supplementary.
also the affidavit in terms of the order dated 15th March 2020. Supplementary affidavit. List it immediately thereafter.
Happy for the respondents, Manoj.
Mr. Mittal, Salona Mittal for the respondents.
Item 21, WPT number 378 of 2021, Mr. Pandey Neeraj Rai for the petitioner. Mr. Ashok Kumar Yadav, Mr. Sunil
Lordship,
Kumar
may I
for the
request for a passover? Mr. Tarun Gulati, who is appearing in this matter, is on his leg in another matter. May I request for a passover?
Today, the state councils have to
Yes, yes,
advance
Manoj.
their
Also, Learned
submissions.
Advocate General is online, Manoj. He will be appearing, Manoj, in this case.
Okay. So,
So may I request to keep it at the end of the board meeting?
let us see. We will just take up the rest matter. Just pass over.
Item 22, WPT number 3133 of 2021, Ms. Seema Kumari for the petitioner, Mr. P.S. Pati, Mr. Ratnesh Kumar for the respondent.
My lordship, the rejoinder was not submitted on time because it delayed in the courier. So I seek apology for that, and I beg it that in this week we would submit it.
Lords, I was directed to file counter affidavit, and I filed it on the next date. That is, on 7th, I had filed my counter affidavit, and they said that they will be filing their rejoinder, which they have not filed.
It delayed in the courier, my lordship. So in this week we will file it.
Rejoinder affidavit and counsel for the petitioner. Miss, what's your good name?
Seema Kumar.
Seema Kumari submits that rejoinder. Seeks short time to file rejoinder affidavit.
Please keep it on next 27th of April, lordship, virtual day.
As the same short time to file rejoinder affidavit. On account of counsel for the petitioner submits that due to delay in receiving instructions and vetted copy of the rejoinder, the same could not be filed till date. She seeks short time to do so. It appears that the counter affidavit in this case has been filed on the 7th of April.
27th of April.
7th of April.
7th of April.
Okay. In that case, it is only 1 week back. So,
They only said that they will be filing the rejoinder within a week.
oh, 1 week time, more time is allowed to grant counsel for the petitioner to do so. Is the case in the week of second May.
My lords, I may pray that if it is listed in the subsequent week of the second week of May, first week I have some difficulty.
And if earlier to that?
Earlier to that, no problem.
Any counsel from outside is addressing for petitioner or local counsel?
Yes, my lordship. Mr. P.K. Sahu from Delhi, he will address the court.
Then in the week of 9th May 2022.
And I'm appearing for the respondent number 1 in this case.
For respondent number 1, Mr. Ratnesh Kumar.
Sir, on 27th April,
I don't have any difficulty.
We can keep it because we have gone through it today. There is a sudden adjournment request.
yes.
The whole question is whether the benefit of that exemption notification would extend to the
Yes.
petitioner.
Exemption will be applicable to the petitioner in the given circumstances or not?
Yes, that is.
27th April. Wednesday.
And one more point, my lord, it's a very premature application challenging the show cause itself.
Yes.
I appear for respondent 2, my lord.
Mr. Pati for respondent number 2. Yes.
Item 23. 5 2021. Mr. Nitin Kumar Pasari for the Amit Kumar for the response.
Because it's a fresh file. Plus the challenge is to the order passed by the revisional authority. The central government. That is
Is it not appealable before the SESTAT?
No. It's not appealable. It's not appealable. The only remedy available is under 226 minutes.
So the only question is whether the limitation period of 1 year applies on your application or not.
Yes, absolutely, Minutes. Because we are saying that 11B is not applicable if we go through notification number 19/2004. Because
that
the amendment.
That may be a clarificatory notification.
The clarificatory
That is the argument of respondent.
Yes, that's the argument of the respondent. In fact, Minutes, various other high courts have already dealt with this issue and has decided the issue in favor of the assessees. Those judgments I will bring on record, and even the notification I will submit, Minutes. I think a counter affidavit would be a necessity, unless, of course, if my learned friend wants to give up.
Lordship, we will file a counter affidavit. Although in a revisional order, Lordship, there is a judgment of Honorable Supreme Court on which
yes.
Yes, Lordship. That issue has been decided on that basis, Lord. And the Honorable Madras High Court as well as the Gujarat High Court has also dealt with this issue, Lord.
If at all they want to file a counter affidavit, then let it come after counter affidavit. We will also file our reply to that. And in the meantime, we will submit the paper book of all the judgments and the notifications.
We will filing a counter approach.
Okay. Lord Counsel for the petitioner submits that the only legal issue involved in this writ petition is whether the application for rebate of excise duty on goods exported during the period January 2015 to March 2015, October 2014 to December 2014, and April 2015 to May 2015, made under Rule 18 of the Central Excise Rules 2002, read with Section 11, capital B of the Central Excise Act 1944, are barred by limitation or not?
Yes.
Limitation period of 1 year or not? Stop. Question mark. according to the petitioner, there being no limitation period specified in the provisions, the limitation of 1 year prescribed by amending notification number 18/2016-CE within bracket NT dated 1st March 2016 could operate retrospectively to bar such a claim. यही ना है आपका कहना?
That is the saying of the respondents, that it operates retrospectively. We say that this notification is prospective in nature.
Will not bar the claim as it applies prospectively. Stop. The petitioner has lost up to the revisional authority, that is the
Which page 183 is the order. That is by the Government of India, Ministry of Finance.
Government of India, Ministry of Finance.
Additional Secretary to the Government of India.
Order passed under the signature of the Additional Secretary to the Government of India.
Yes.
Annexure.
This is Annexure 7, page 183.
7. Stop. Then counsel for the para, then counsel for the respondent praise one is allowed. How much time, Mr. Amit?
3 weeks time.
3 weeks time to file counter affidavit. 1 week thereafter to the petitioner to file reply if so advised. This is the case after 4 weeks.
Much appreciated.
Item 24, WPT number 1125 of 2022, elaborated for item number 25. Mr. Anish Kumar Mishra for the petitioner, Mr. P.S. Pati, Mr. Prasant Pallo, Mr.
Yes, my lord, my senior Mr. Gopal, sir will assist this court, your lordship.
Lordship, may please your lordship. In instant case, lordship, we have filed this petition challenging the jurisdiction of state of Jharkhand to levy VAT on the goods which were supplied from Karnataka or Maharashtra on benefit of CST. Is being an interstate sale, and in my case, lordship, not only this issue is there in other high court, we have got the favorable ruling up to the level of Supreme Court also. Before that, may I give this background of the entire issue?
So why did you not go before the tribunal, commercial practice tribunal?
Lordship, we are questioning here the jurisdiction itself of the authority.
No, but it involves issues of fact, as it appears that some part of your turnover has not been properly explained.
Lordship, facts, the way these are clear in the assessment order, I'll be relying on those facts only. And those facts very clear.
The learned tribunal should also take into consideration.
Lordship, even in earlier cases also we filed the writ petition, those were also stand admitted, and this is a periodical issue. Lordship, brief background.
Just a minute.
Lordship, we are engaged into the business of...
Just a minute.
Actually, sir, this was perhaps in similar matter has been tagged with this.
Writ petition 3647 and writ petition number 3668 of 2016, Lordship.
Those petitions have been admitted.
And interim stay, full interim stay has been granted, Lordship.
Order dated 3 of the tag case 3647.
Yes.
3647.
Same stand was taken in those writ petitions also by the state.
Lordship. May I give a brief background, Lordship, what is the issue involved? Lordship, I am engaged into the business of supplying and erection of lifts and elevator. Lordship would be aware that lifts and elevator, once installed, becomes part of the building itself. In my own case, there are decisions by Bombay High Court as well as Supreme Court in case of Kone Elevator 2014 that lift is an immovable property and it amounts to works contract. Now, Lordship, what happens that my factory is in Karnataka, my warehouse is also in Karnataka, one warehouse is in Maharashtra. When any customer who is there in the state of Jharkhand wants any lift, he will give us the specification, like what would be the capacity, what would be whether it will open at both end, number of floors, number of person who can be there lifted by the lift. So those specifications are given and a customized product is always delivered. Based on the contract which is received, then instructions are given to Karnataka factory to supply the manufactured part or the bought out part in pursuance of an existing contract. Lordship, it is a settled position in law, be it Supreme Court in case of NTPC, Builders Association, and in number of High Court decision in case of other elevator industry, that in pursuance of a works contract, when the goods are supplied from the other originating state and CST is paid there, then there is no question of again taxing it in the state of Jharkhand. That is precisely the issue which is involved in this particular case. Lordship, what has happened in this particular case, it is the stand and contention of the department, the respondent, that one, you have used the form Sugam G. The law itself, Rule 42 itself says the Sugam G cannot be a criteria to decide the nature of transaction, be it an intrastate or interstate. Point number two, they are saying that no, your Jharkhand registration, it becomes a distinct person, therefore it is as good as a purchased by the Jharkhand registration. There also, Lordship, in case of English Electric Company and the other decisions, clear cases that situs of sale is not an important. Even when the entire contract there is a role of branch office, that is also not important. What is important is, which is precisely section 3 of CST Act, that if a contract occasions movement of goods from one state to another, then CST is required to be paid in the originating state, which I have paid, and that is not being denied also. Lordship, may I just have your kind attention to only two paras of the assessment order. In writ petition number 5531, it is at page number 139. I'll request your Lordship attention to page 141. 141, wherein the respective portion of what is the contention of the department and how it is directly in the teeth of so many judicial precedents which are there on the subject.
Yes.
Lordship, I'll just read page 141. उक्त तालिका के अंतरराज्य भंडारण अंतरण के लिए ₹500 का सुगम जी निर्गत किया गया है, जबकि दाखिल विवरणियों के अंतरराज्य खरीद और आयात रुपए इतना दर्शाया गया है। इसके अतिरिक्त व्यवसायी द्वारा मैन्युफैक्चरिंग और प्रोसेसिंग, रिसेल एंड सेल्स ट्रांजैक्शन के लिए निर्गत किया गया है। व्यवसायी द्वारा वार्षिक राशि का सुगम जी वास्ते इतना रुपया सेल्फ कंजम्पशन के लिए निर्गत किया गया है। इस संबंध में व्यवसायी के प्राधिकृत अधिवक्ता द्वारा दाखिल लिखित स्पष्टीकरण क्रमांक 1B में बतलाया गया है कि any MOD sale, Lordship, that means new installations, that new contract. Any MOD is a new installation contract wherein the new orders for the lift and elevators are placed by the customer on the company. The mechanism works as under. Say the order for manufacture, supply, erection and installation of the elevator is placed by a customer in Jharkhand. Since the contract is a works contract, the same involves supply of material and labor. According to material component amounts to almost 80% and labor comprises of 20%. Of the 80% material component, the main material is supplied from the company factory located in the state of Karnataka directly. There is no dispute later on that these are supplied from Karnataka and CST is paid from the state of Karnataka directly by the company at the site of the customer, where the elevator is required to be installed. Since the supply is assigned to the contract and delivered to the site of customer, CST is levied on such supplies from the state of Karnataka. For other supplies of material, the same is minimal, very minimal, and procured within the state of Jharkhand, on which local Jharkhand VAT is levied. The service and labor towards erection, installation, commissioning of the elevator service tax is charged on 20% portion. Hence, the turnover deduction is claimed toward material supplied from Karnataka
on which CST is levied and service and labor component on which service tax is levied. So this is my factual profile that the goods which are required for the purpose of execution of the works contract are supplied from Karnataka. Our CST is paid thereon. Now, Lordship, since this is the model which I am following in the entire country, so be it a customer in the state of Jharkhand or be it a customer in the state of UP or be it a customer in the state of Delhi, the same tax position applies. Lordship, in my case, in the territory of New Delhi, the similar matter arose and it went up to Supreme Court. And one position which is very commonly held was that I am not required to pay VAT in the state of Delhi. Lordship, I have submitted compilation and I would like to refer to such specific case. There are plenty of cases on this particular issue, but may I just refer my own case?
Yes.
Lordship, I have submitted two compilations. The one compilation which is which is in which is of 138 pages.
Yes.
Lordship, in that particular case, may I have your kind attention to page number 10.
Yes.
In the High Court of Delhi, page number 10, the same issue which has been there, and I will start reading from Para 2 itself, Lordship. The SSC is engaged in the business of supply, erection and commissioning and installation of lift and elevator in various classes of places, including residential building, government offices and hospital. It is also a registered dealer under the provision of Delhi Sales Tax Act. It however has its manufacturing facility at Mumbai, where its components are produced. The Mumbai unit also stores and products are manufactured. The Delhi Sales Tax Authority sought to assess the transaction for 3 distinct periods covering assessment year 2002, 3, 3, 4 and 4, 5. The assessing authority sought to hold that the burden of local sales tax levies was laid upon the dealer upon an analysis of the contract entered into. What prevailed with the adjudicating authority was that the contract was indivisible works contract, title of each elevator passed on to the customer upon payment, and for the purpose of dispute resolution, the Court of Delhi had exclusive jurisdiction. The assessment were subjected to appeal and so forth. Now I'll read Lordship Para 3. Learned counsel sought towards the tribunal made an error in holding that Delhi sales tax did not apply. He relied on the decision of Kone Elevator India Private Limited versus State of Tamil Nadu, and also stated that the sale of the right to use the elevator was concluded in Delhi, which was also the place of performance of the contract, that is installation and commissioning. He also relied on the decision of Supreme Court in Larsen and Tubro versus State of Karnataka. The relevant finding of the VAT tribunal allowing KSS's appeals are as follows. Then, under the inverted comma, the above decision makes it clear, which refers to various decision in case of electric elevator or lift and elevator industry also, as well as Honorable Supreme Court decisions in case of English Electric, NTPC, Builders Association, and so forth. The above decisions make it amply clear that goods that are moved from outside the state constitute interstate sale and are to be treated as such. Para 26, the learned FFA rejecting the appeal has observed that the dealer has entered into the works contract with various contractors in Delhi for supply and installation of elevator lifts. The contractors have deducted TDS, which supports the argument of revenue that the transaction entered into by the dealer are not central sales but the works contract executed in Delhi, as held in the case of Builders Association. Ordinarily, unless there is a contract to the contractor, in the case of works contract, the property in the goods used in the construction of a building passes to the owner of the land on which the building is constructed when the goods or material used are incorporated in the building. Clause 3, accordingly, the property in goods passes in Delhi at the time of execution of works, but on going through the contract, which are similar in all cases, the time of transfer of property is when full payment is made. Some of the clauses have been reproduced below. Lordship, all these clauses are my standard clauses. It remains there in all my contracts. Then, Lordship, may I read clause 4. There is nothing on record that the lifts are manufactured at Bombay and then sent to Delhi in semi-knockdown state and fixed here as such in an interstate sale. The sample agreement placed on the file does not mention the goods are to be delivered from Bombay. There is no mention of the argument that the specific goods are to be used in the installation of lift and they are to be procured from Bombay or elsewhere, there is no priority of contract to send them. So this is what they are recording. Then para 27. Appellant has placed on record copy a contract giving specification for supply, installation and commissioning of elevator at the customer site at A. Pitambura is submitted. The proposal contains detailed specification of the list as ordered by Delhi-based customer. These specifications are as per the individual requirement of the customer, which remains in all my cases. Appellant submission is that a specific contract is affixed on each of the contract with the customer and the same affixed contract number. Because Lordship, this is the case. Whenever I enter into a contract number is generated and all the supplies, whenever are made, there is a reference to that contract number in all the documents which under which the goods move from Karnataka to the state of Jharkhand. Contract with the customer and the same affixed contract number also figure in the invoices issued by the appellant. While the invoices indicate that the concise in Delhi branch office
Mr.
of
Counsel, you have been reading from which page?
Lordship, I am reading in para 27, page number 12.
Page number 12?
At the bottom, Lordship. Of the compilation, Lordship, that 138 pages compilation.
You indicated that serial number 10 and then perhaps you took up this page number 10.
Lordship, page number 10 is the decision of the Honorable
Part of Supreme Court decision.
Supreme Court, Lordship, against this decision, department went to Supreme Court and that is at page number 16. Lordship, but prior to that at page number 15, may I just read para 4, page number 15, Lordship.
Yes.
The court is of the opinion that, Lordships are with me.
Yes.
Page number. The court is of the opinion that appreciation of the law by the tribunal in this case is sound and unexceptionable. The placement of an order by the agent for procurement of lift in this case was merely an offer. It is only upon its acceptance and further steps taken by the supplier that an offer crystallizes into binding promise or contract. That took place in Mumbai. It is now too far well settled that the incidence of central sales tax or even sale of goods occur where the goods are appropriated to the contract. In this case, the place where the appropriation took place is undoubtedly Mumbai. This court's conclusion is also supported by similar reasoning adopted in ThyssenKrupp Elevator versus Assistant Commissioner or decided by the Karnataka High Court on 24th of April 2018. Thereafter, Lordship Department filed an appeal before Honorable Supreme Court and the Supreme Court rejected the same, saying that that is at page number 16, Lordship. Delay condone, we decline to interfere. The Lordships are with me, page number 16.
Page?
16.
Is the Supreme Court's judgment.
Lordship, Supreme Court. So after the decision by Honorable Delhi High Court, Department went to Supreme Court also on this particular point, and the Honorable Supreme Court is stating that we decline to interfere in the civil level special leave petition is accordingly dismissed, and in view of the above, pending application shall stand disposed of. Lordship, there is also
this Delhi judgment, Mr. Counsel, this Delhi judgment also, High Court judgment arose from the Appellate Tribunal of the Value Added Tax, Delhi.
Lordship, that is the fact. But Lordship, in this particular case, the question what I am raising is the jurisdiction, and there are ample judicial precedent, Lordship, that alternate remedy should not be a bar in cases where I am challenging the jurisdiction of the authority to levy. Lordship, understand my situation, kindly appreciate. I am already paying tax in the state of Karnataka. Again, if I will be asked to make the payment of tax in the state of Jharkhand, 14.5% there and 14.5% in the state of Jharkhand, And Lordship, these facts are not under dispute. Lordship, may I have your kind attention to the counter which has been filed. Para 19 and para 20. The counter in the case of writ petition 5531. May I just read para 19 and 20? The facts are not under dispute.
Mr. Counsel,
Lordship,
the Delhi High Court judgment at page 10, which you are relying upon, that judgment has not been produced. I mean, the compilation doesn't contain the complete judgment. Pages are missing in that judgment also. You see, after page 3, there is page 10, there is page 11, continuous, in which paragraph 26 starts. Then at page 12, paragraph 27 starts. Then page 13 has a completely blank space after a small paragraph. The compilation is not complete.
Lordship, am I audible?
Yes, yes.
Lordship, even there is a decision by Honorable High Court of UP also in my own case. May I refer to that, Lordship? That is at page number 137 at the end.
This is basically court of one judgment of Supreme Court, Larsen and Toubro.
Lordship.
Page 10. And
in fact, Lordship, for the Lordship.
No, brother, I have a different judgment at page 10. Perhaps my judgment is of High Court of Delhi, Commissioner of VAT Delhi versus Otis 11.
Yes.
Lordship, that is
last three lines. Last three lines.
Last three lines. But thereafter, the entire judgment is not there in the compilation.
Entire judgment is not in compilation. Missing part.
Lordship, actually the serial number 1, 2, 3 and thereafter there is a quoted portion from 25 onwards. Lordship, Lordship is looking at page number 11, that is an extracted portion.
But this judgment is of how many paragraphs? Where is the end part of that judgment?
End part is, Lordship, at page number 15.
Paragraph 5 is the last. Paragraph 4 is the finding in this case.
Absolutely, Lordship. Absolutely. 4 is the finding. So, Lordship, 1, 2 are the facts, and then in 3 there is an extracted portion which start from clause 25. It ends at clause 30 at page number 15. Then the finding is at,
okay.
Then the finding is at paragraph 4, which is at page number 15.
Who is for the state?
Lordship, may I show few more decisions in the case of lift and elevator industry only?
No, we will come to that first. Who is appearing for the state?
I am for the state in serial number, Your Lordship. 25, Your Lordship.
What is this habit of putting off your screen when your case is going on and you are not present in the court, even in virtual?
I'm sorry, Lord.
Asks, no, nothing to be sorry about. We are going to comment upon the counsel for the state or any counsel who is not appearing on the screen, neither excuses himself from the proceedings of the court. Every time I find one or the other state counsel doing this thing, as if we are passive, you are passive listeners, and let the petitioner do his job. Neither the JC nor the senior counsel, none of them were appearing on the screen. There are 2 writ petitions connected. Are you taking the court for granted because of our soft approach?
No, Your Lordship.
I'm sorry to say that. I have been watching this. I generally tend to ignore. Sometimes the connectivity is poor. The moment the court asks, then you put on your screen and appear. There should be uninterrupted appearance and attendance of counsel for the parties in any proceedings in any court unless the counsel seeks a liberty to go or excuse to go to another court.
Yes, Your Lordship.
Mr. Sachin, your junior has not been assisting this court in a proper manner.
My lord, I will take care, my lord. He was there, why he did not, my lord, on his camera?
Most of the time he is seeking an adjournment on your behalf, but whenever it comes to assisting the court, either he is off the screen or is not ready.
Lord, I will take care, my lord. I am extremely sorry, my lord. Taking apology for that. Actually, I got, my lord, stuck in another court, my lord, so that's why I was not here.
That's something else, but at least you have, there are two state councils, PS Pati and...
Yeah, actually, both the matters have been, my lord, that matter has also been transferred to my office, my lord.
Okay, then all the more reason.
My lord. My lord. My lord, in the first case also, my lord, I have received instruction and counter is almost ready, my lord. If your lordship permit me, my lord, 2-3 days time, I will be filing the counter affidavit, my lord, in that case also.
My lord, the counter has already been filed on 5531. Is the same issue. The only change is the period involved. Nothing else. And lordship,
They cannot be stopped from filing their stand.
No, I'm not. I'm just placing this.
I'm just praying for 2-3 days time, my lord. Counter is ready. I will be filing, my lord, by Monday. Let it be, my lord, on any day suitable to your lordship. My lord, my letter friend is argued, my lord. I will, my lord, argue on that.
And lordship, my request would be if your lordship can allow that at this stage, if it be admitted with interim protection, and then all these writ petitions may be listed together. There are two which are there for the previous period.
Those are admitted for hearing. Mr. Sachin, are you aware that
yes, my lord, yes,
on the same issue there are two petitions admitted for hearing?
2016, my lord, the petition was filed, and my lord, on the very first day, my lord, time was granted for filing counter affidavit, and my lord, the stay was granted on the very first date. Perhaps, my lord, that stay order has not been further extended, to my knowledge, my lord. If I am not, my lord,
there is no expiry date to that stay order.
Oh, that is your submission. My submission would be, my lord, that the stay would automatically, my lord, got vacated in view of, my lord, the AC of the surfacing judgment after expiry.
Lordship, that order by this Honorable High Court is at page number 153, Lordship.
No, that has been extended later on, but of course, that doesn't mean that the stay becomes inoperative. The point is, Mr. Sachin, the point is that if the same issues are involved, then it would be unnecessary to insist upon the petitioner's counsel to argue it afresh at this stage.
Definitely, my lord. Your lordship will remember, my lord, I had pointed out that two matters are pending. My lord.
The order dated in that case which is admitted, the ad interim stay shall be continued till further order.
Absolutely, Lord.
So it is not that it is for a particular next date of hearing.
I am grateful, Lord.
Actually, my lord, my understanding was, my lord, based on, my lord, this ACOD surfacing judgment, that stay will automatically be vacated, my lord, unless it
Since
is
all the matters are common and petitioner is also common.
Yes, there is no dispute with regard to that. I am not disputing that.
If that is so, then instead of hearing at the at length at an interim stage, we may tag the present two writ petitions with those two writ petitions, grant the same kind of interim order, and order them to be listed for hearing on any week or day.
Grateful, Lord.
I will be, my lord, ready for any my lord, earliest date for argument, my lord. But, my lord, since they have directly come against the, my lord, order of assessment, some kind of, my lord, direction will be given, my lord, to deposit certain amount at least before the suitable court. My lord, since the past interim order, my lord, in some other cases, at least some amount will be directed to be deposited before the Registrar General at least, my lord.
This is certainly not a case, Lordship, for any pre-deposit whatsoever. And Lordship, as I read,
that was not a condition in the previous interim orders passed by the two writ petitions admitted by the common order and thereafter separate writ petitions admitted and they were combined, and then the interim order has been continued.
Yes.
Lordship, may I request if it can be posted for a final hearing, because what it involves is a question of law as to the jurisdiction of state of Jharkhand to levy fees.
That we will see, Mr. Counsel.
And all the 4 petitions, Lordship, can be listed together for that purpose. Because Lordship, this is an industry issue. In fact, this was an industry issue, and there are sufficient number of ruling by the Honorable High Court of Karnataka, Honorable High Court of Madras, Honorable High Court of Rajasthan, UP and Delhi in my own case.
Click here. Then counsel for the petitioner submits that the legal issue involved herein is whether the respondents are justified in levying VAT on interstate supplies in execution of works contract which has been already subjected to CST in the state of origin. Stop. Learned counsel for the petitioner submits that on same and similar issues concerning different assessment years. What was the assessment year of that?
Lordship, 2009, 10, 9, 10, 11 and 15, 16. 15, 16, Lordship.
2009-10 and 15-16.
15, 16. 9, 10, 10, 11 and 15, 16, Lordship.
9, 10, 10, 11. 9, 10 and 10, 11 is in which writ petition?
That is in 3668, Lordship.
3668 of 2016 and
15, 16.
2015-16 in WPT number 3647 of 2016.
15, 16, 3647, Lordship.
This court, a coordinate bench of this court has been pleased to grant ad interim stay of the operation of the impugned order of assessment and the demand notices, impugned orders of assessment and the demand notices. Stop. The present writ petitions relate to assessment years 2017-18 and
2017-18 and 2016-17, Lordship.
2016-17 in WPT number
5531.
5531 of 2021 and 2017-18 in WPT 1125 of 2022.
Lordship.
Stop. Learned counsel for the petitioner has also placed reliance on decisions of other high courts, such as in the case of the same petitioner, such as of the Delhi High Court, in the case of the same petitioner, in ST Appeal number 1 of 2018 and CM Appeal numbers 48717-48720 of 2018, judgment dated 26 November 2018.
And also UP High Court, like Lordship Lucknow bench, page number 137.
137 of the same compilation.
Lordship. Trade Tax Appeal 170 of 2010, Lordship.
Trade Tax
Revision 170 of 2010.
Every order is subsequent to tribunal's order.
Lordship, there the amounts involved were very, very low. In the state of Jharkhand, the demand what has been raised, Lordship, is 1 crore 91 lakh.
That won't determine.
Lordship.
The only thing is that you have got a stay in a previous.
Lordship. And it's a jurisdiction matter, Lordship. It's a question of jurisdiction, Lordship.
The stay in the previous order, that's the issue. Otherwise,
The judgment of the Delhi High Court has been affirmed by the Apex Court in Special Leave Petition Civil Diary number 39203 of 2019, by judgment dated 10th January 2020, whereby the special leave petition was dismissed in limine. Stop. It is submitted that since the issues involved are common, the present writ petitions may be admitted and tagged along with the writ petitions number so and so 3647 2016 and other one of 2016. And similar interim relief may be granted to the petitioner. What is the condition of pre-deposit? Condition of pre-deposit in a appeal before the Commercial Taxes Tribunal. Mr. Sachin. Mr. Sachin, what is the...
Yes, Lord, I have come. 10% of the tax assessed.
10%.
My lord.
Which section?
My lord, you also kindly see, my lord, 80, my lord.
80, division. Section 70.
80, my lord. Provided that Commissioner on an application for division of any order of the assessment of penalty, both passed by the prescribed authority under this Act, may direct such dealer or person to deposit a sum not exceeding 10%. That is with regard to commissioner.
No. So in this case, the appeal would lie before the joint commissioner or before the tribunal.
It will be before the what?
Respondent number 3 is whom? Assistant commissioner. So the appeal would lie.
Lordship, instead of revision, section 79 is the one which is there.
Yes, right.
And there
20% of the tax.
Sorry, we have below the appeal will lie, not below the revision. I'm sorry, Lord. Appeal because it's
Appeal
directly
will lie
against
because the adjudicating assessing officer is the assistant commissioner.
Yes, my lord. Yes, my lord. And
So
against the order of assessment is going to file.
So, Mr. Counsel, interim order subject to deposit of 20% of the tax.
My request would be, Lordship. This is a case wherein I have already paid 14.5% in the state of Karnataka. And this is a case which is covered in my own case, and not only in my own case, for the entire industry. And Lordship, I can show at least 10 decisions. Same fact profile, elevator supplier supplying from one state to another state, paying in the original state, and the demand has been scrapped and set aside in all these cases. Not only one, I am saying at least 10 cases I can cite, Lordship, and 3 in my own case. So this certainly, Lordship, doesn't require any such condition, Lordship. There would be great hardship, Lordship. My request would be, in fact, Lordship, what submission I am making is, Lordship may fix a date next week or any other date what my learned friend is available and convenient. We can list the matter on for the purpose of final hearing, and Lordship, I'll convince and demonstrate that there is no case whatsoever the department has to again tax the goods which has already been taxed in this Karnataka. And the counter what has been filed in 5531, Lordship, there is a clear admission. Their stand is that no, you consider Jharkhand as a separate, distinct person. And English electric decision, Honorable Supreme Court says, even if the branch is involved for the purpose of getting the order and implementing it, may I show, Lordship, those decisions? Clear precedent. This is a case, in fact, I am really astonished when we see this sort of orders from the state authorities. When there is a clear jurisprudence available, the law is so clear, and in my own industry, in my own case, still such orders are passed. And what is the basis? They say that Form G has been used. Rule 42, Lordship, there is a legislature intent clearly made explicitly in the book statute itself, which says that the Form G cannot decide the nature of transaction. And they are just going against this specific explicit provision in the law. Lordship, may I show Rule 42 for the time being, which is at page number 7 of the same compilation. The basis what they are adopting is clearly in the teeth of the law. Page number, Lordship, the Rule 42 starts at page number 7 of my compilation. And at page number 9, the proviso to 10, the declaration forms as prescribed in those rules shall not be transferable, provided the prescribed declaration under this.
So, Mr. Counsel, you deposit the 20% of the tax amount.
Lordship, that would be great hardship to me. Lordship, there are clear precedent. There is one piece of evidence or one case law, Lordship, the other side can show which is there.
They will show the court.
Lordship, 20% would be too high, Lordship.
That's the statutory.
So that is exactly the hardship what I have while approaching this court.
Then wait till the final decision. Let them take steps for recovery. Wait till the final decision of the case. We will simply tag it along with the rest 2 writ petitions.
Lordship, I am at your disposal, Lordship. I am just making my submission and prayer, Lordship.
Yes, we appreciate that. The judgments which you have cited have come through the Central Excise Tribunal.
Lordship, may I show even Magad Sugar and the other decision wherein a regulation under 226 has been admitted? on the question of jurisdiction on the same issue, interstate versus intrastate.
We do not have the benefit of the findings on fact by at least two inferior authorities.
Yes.
And you want us to get into the findings of fact straight away from the assessing officer. Then deposit the 20% of the amount.
And below 226 below discretionary jurisdiction, your lordship may impose
That
condition
we
below directly.
understand. That we
Yes,
understand. That we
You
understand.
can take the petition directly without availing the remedy of appeal. Your lordship.
The only thing is that the petitioner's two other writ petitions have been admitted. There is an interim order, but the interim order doesn't have a precedent value. Interim orders can be passed on each petition depending upon the discretion of the court.
Lordship, may I request instead of 20%, Lordship, can it be made 10% or 5%, Lordship? Because this is certainly not a case, Lordship. This is clearly in the teeth of so many judicial precedent. There has to be some.
Whether any concession on the percent or should be?
On the one hand, sir, so far as
in fact,
direct
Lordship,
is concerned, I am with same view.
in fact, even under section 79,
Please
Lordship,
hold, Mr. Mundra. Please
Yes.
hold.
As you please, sir.
Anyway, then 15% of the
Lordship, may I make one point? Even under section 79, the proviso talks about 10%, Lordship. My friend, learned friend.
no appeal under section 1(2) shall be admitted unless the dealer objected to an assessment order has spent 20% of the tax assessed or full
The
amount.
latest, Lordship, the latest one.
Therefore,
The latest one. It says 10%. And also there is a provision for stay.
Petitioner has pleaded hardship in respect of any pre-deposit, be that as it may, since common issues are involved, since issues, writ petitions involving common issues have earlier been admitted for hearing. Stop. Notice will have to go to two other respondents also, state of Maharashtra and state of Karnataka.
Lordship, state of Maharashtra and state of Karnataka are not there as part of this one. Okay?
No, in your present writ petition, both the states are there.
Lordship, my apology, Lordship, mistake at my end here.
They are party.
Okay. Counter affidavit has been filed in WPT number 5531 of 2021. Learned counsel for the state seeks 1 week time to file counter affidavit in WPT number 1125 of 2022. Stop. Let notice issue on respondent number 4 and 5 in both the writ petitions under registered cover with heady and speed post, for which requisites be filed within 1 week or 2 weeks. 2 weeks.
2 weeks once.
Stop. These writ petitions are also admitted for hearing. Stop. Subject, in the meantime, subject to deposit of 15% of the
Lordship, even the law prescribes 10%, Lordship, for appeal.
Just saw the 20%.
Lordship, I don't know the date of publication, but I just saw it. 79 is in front of me. Lordship, I'll just reflect it on this on the screen, Lordship. Just reflect it on the screen.
15% would be there.
Lordship, 10% is mentioned in 79, Lordship.
Which
And
book?
this is something, Lordship, with my learned friend Sachin Kumar can also confirm. It's 10% under 79.
Which book are you reading? देखें वैल्यू एडेड टैक्स दूसरा बुक इसके पहले वाला जो है
In fact, in my compilation also, Lordship, page number 7, the second compilation, which is of page 234 pages.
We will go by the book. Just wait. The old book also has 20%.
Lordship, the new book.
Page 679, section 79, page 6 of your compilation also. It is 20% there.
Yes, 20%.
Yes, mention वही किया हुआ है. No appeal under 1 and 2 shall be admitted unless the dealer objecting an order of assessment.
Lordship, I'm just sharing the screen. I'm just taking it from the site itself.
No, please, Mr. Counsel, don't show something which has a tendency to mislead us.
No, Lordship, there is no. In fact, that's what I'm saying, Lordship. My learned friend is also there. He is also doing these matters day in, day out. He can also confirm.
Your compilation itself contains the same provision of 20%. We are giving you a concession of 5% with whatever you are pleading and the previous two orders passed.
Lordship, may I just share this? It's what is there written in the statute, Lordship. I'm not changing any number.
No, we are not even going by the statute. We are reducing it by 5%.
Lordship, it got changed. Earlier it was 20%. From 2016 onwards, November 2016, it became 10%, Lordship. And my friend can confirm this, Lordship. I'll urge Mr. Sachin Kumar to just confirm.
You yourself have given the compilation which contains 20%. Why are you confusing us now?
Lordship, 2016, there was a change, Lordship.
And apart from that, the writ court has the discretion to impose any condition.
Lordship, 2016 November, there was an amendment, 20% got reduced to 20%. I'll urge the other side also to confirm this position. So, Lordship, whatever this honorable bench decide, at least should be on the right understanding of what is the current law. That is 10%, Lordship.
Good. Why did you annex that?
I'll share the notification number also, Lordship.
Sir, may I, sir, I saw from the Google, sir, amendment in section 79 in 2016. It is 10%. That is there.
Okay.
Provided the evaluator authority is satisfied that there is sufficient ground, he may on application exempt the applicant from paying 10% का exemption है, but originally it was 20%. Thereafter it was 10.
I'm grateful, Lordship. So 10% is there, and even there is on satisfaction.
Yes,
it can be reduced and it can be set aside also. So, Lordship, my request would be that not from 20%, if 5% can be stated, Lordship.
This is too much, Mr. Counsel.
Lordship, this is a case clearly in the teeth of so many decisions.
That is okay, but the flow of you cannot avoid the two tribunal. That the legislature has some object of constituting the two tribunal. Two-tier court tribunals, because they will verify the fact that tribunal is the last fact-finding authority.
Lordship.
The law is okay. The judgment is okay, but everywhere it is after that.
In the meantime, subject to deposit of 10% of the amount of the assessed tax, the respondent shall take within a period of by 20
20
25th of April 2022. Before your office, Mr. Sachin?
Yes, my lord.
Uh, in the state exchequer through Challan, the respondent shall not take any coercive steps pursuant to the impugned orders of assessment dated 26th February 2021. Sorry, 18th August 2020 and 26th February 2021 in the respective writ petitions concerning and the demand notices of the same date in the respective writ petitions for the relevant assessment years 2016 finance, 2016-17 and 2017-18, first quarter, financial year. Stop.
Lord, for the period 2016-17, the demand notice is dated 20th of August 2020.
हाँ वो लिखा दिए. मिस्टर अनीश मिश्रा, आपका प्रिपरेशन बहुत पुअर रहा है. Let the matters be listed under the heading for hearing, if possible, in the month of June 2022.
Immensely obliged. Lordship, may I take leave of the court?
Yes.
Passover case, item number 21, WPT number 378 of 2021, Mr. Pandey Neeraj Rai for the petitioner, Mr. Ashok Kumar Yadav for the respondent.
Wait, please, Your Lordship, notes, Lord, we have given our written submissions also, notes enclosing notes, certain note judgments and certain extracts of the forms and the rules.
Yes.
The note petitioner note seeks a declaration that retention of import, not the issue here, that what he seeks to raise is, Lord, the retention of import and countervailing duty paid by it for a stock of which the shelf life had expired and which had not undergone retail sale, and therefore it is arbitrary. Consequently, it seeks refund of such duty paid to the extent of 1,53,68,480. Now, notes the certain notes, immediate facts, notes me just note. That note, he is not a manufacturer in the state of Jharkhand.
Yes.
He is admittedly not having a manufacturing facility, not having breweries in Maharashtra, Telangana, West Bengal, Himachal Pradesh, and Arunachal Pradesh, from where he imports beers into the state of Jharkhand.
Yes.
After the import, as per the supply agreement, the beer is then sold to the wholesaler. That is respondent number 3, JSBCL. These not facts, but there is no dispute.
Yes.
And then he says that not the entire dispute stems from the fact that certain stock of beer, Lord, which Lord, came to be destroyed because it having become unfit for consumption, because it outlived its shelf life of 6 months. This was during the period of COVID, note that it says, and this imported beers never left or were removed for retail sale or even to the warehouse note of the wholesaler. The incidence of duty never happened. Thus, the countervailing duty paid on such stock must be refunded.
Yes.
But this is not in nutshell, not the case of the petitioner. Now, for not us to not to take up not the matter, not the we are concerned not the statutory provisions of not countervailing duty and not the excise duty. The countervailing duty, lords, has been interpreted not in a number of judgments. It is not order to not compensate. It's a compensatory duty for those, because any not manufacturer who has no manufacturing facility within the state will be not liable to pay excise duty. So an importer not who has a manufacturing facility outside the state will be liable to pay countervailing duty to put it on par or equal playing field, not with a manufacturer who is from within the state. This is the concept of countervailing duty. Now, the incidence of countervailing duty, Lord, arises immediately when the goods are imported. That, Lord, is the definition. Lord, may I not begin with the definition, and then Lord, sir, may just see not certain provisions which I would be referring to. The entry 51 of list 2, Lord, has given it, Lord. It says the duties of the excise on the following goods manufactured or produced in the state and countervailing duties at the same or lower rates on similar goods manufactured or produced elsewhere in India. A, Lord, is alcoholic liquors for human consumption. Definition of 26A also, Lord, of the Excise Act says the same thing. Lord, just take up the Lord Excise Act. Lord, Bihar Excise Act 1915.
This is part of their compilation, Jharkhand Excise Act 1950.
Their compilation. All right, not take up not that from there also. I am referring to section 2, not 6A, 6 small a.
Yes.
This note says excise duty and countervailing duty means any such excise duty or countervailing duty as the case may be, as is mentioned in entry 51 of list 2 in the 7th schedule to the Constitution. Seventh schedule mode is I have already not said. Mode is the entry 51, list 2. Then modes will come to section 9. It restricts the import into the state unless certain conditions are fulfilled. It says that no intoxicant shall be imported unless, I'm reading 9.1.
Yes.
No intoxicant shall be imported unless the state government has given permission or either general or special for its import. Such conditions as the state government may impose have been satisfied. Ask him to stop for a while. The duty, if any, payable under Chapter 5 has been paid or a bond has been executed for the payment thereof. So therefore, not in case of any import, it is not subject to the restrictions and it is subject to the duty not which is to be paid. Then if my lord would come to note section 12. It says that no intoxicant can be imported except under a pass. Now, Lord, I will refer to Lord, the relevant notes provisions in detail under the rules, how Lord, a pass is generated, and how the goods are imported. Section 12 says passes for import, export, or transport. No intoxicant exceeding such quantity as the state government may prescribe by notification, either generally or for any specified local area, shall be imported, exported, or transported except under a pass.
Yes.
Words may kindly see 12.2. The passes required by subsection 1 may be granted by the collector.
Yes.
No, subsequently, there are two provisions with the after note, section 27. And this is not a Reconstruction Act, and not 1915 Act, not, and more or less not the Excise Act, not the other states also are the same. Not the provisions are parameteria because it is not a pre-constitutional law, but which was prevalent in all throughout the country at that relevant time. Kindly note come to thereafter section 27 and 28.
Yes.
Lords have got this section, Lords. Power to impose, section 27 in the chapter 5. Power to impose duty on import, export, transport, and manufacture, an excise duty or a countervailing duty, as the case may be, as such rate or rates as the state government may direct, may be imposed either generally or for any specified local area on any accessible article imported. What's A? Now, this note, therefore, the incidence note of imposition of countervailing duty starts from the very fact of the entry of the goods into the state. The moment it is imported.
Yes.
Then note section 28 says ways of levying such duty. Subject to any rules made under section 60, clause 12, any duty imposed under section 27 may be levied in any of the following ways on an accessible article imported by payment upon or before importation in the state or territory from which the article is brought, or by payment upon issue for sale from a warehouse established, authorized, or continued under this Act. So, this is not section 12, not which has been very extensively argued by the petitioners. It is not the incidence, it is the method of collection of the duty, which can be deferred to a distant time or an action or a cause of action, which can be different and distinct from the incidence of the duty, which is the import itself.
No, but it says way of levying such duty.
Way of levying, yes. Ways of levying such duty. Therefore, how the duty has to be levied. Either you have to pay it in advance before import, or at the time when it leaves the warehouse, or at the time of sale, or wherever at any other distant time of action, it can be levied. So it is a way of levying, means not the method of collection or quantification of the duty which is prescribed under section 28, and has nothing to do with the incidence of duty, which is section 27. Now, this was exactly the case in the S.K. Patnaik matter, arising out of Lord Odisha, notes where the Supreme Court notes was considering the very same provisions of Bihar and Odisha Excise Act. And the similar facts were there that the articles had become unfit for consumption. And just notes for notes, 2-4 paragraphs note the judgment. It's a very short judgment, may not should take. 2000 volume 1 Supreme Court cases 413.
Page 18.
Note is there, not in the written submissions. Page 18. Now, I'm going to come to note the. May I read note from paragraph 2 onwards?
Yes.
Brief facts giving rise to the present appeal are as follows. The appellant imported into the state of Odisha Indian-made foreign liquor and stored it in a licensed bonded warehouse from where the liquor was to be released for sale. While the liquor was so stored in the warehouse, a portion of the imported stock became sedimented and was redeemed unfit for human consumption. That stock was therefore destroyed. A notice was issued to the appellant for payment of the countervailing duty on the stock to the tune of rupees so and so. The validity of the demand of countervailing duty was challenged by the appellant in a writ petition. It was asserted that since the stock of liquor had been destroyed in the warehouse, countervailing duty could not be imposed. Now note paragraph 4, 5 and 6. Excise duty, not in a very cryptic form and not beautifully it has been explained. Difference between excise duty and countervailing duty. Excise duty and countervailing duty are well-known concepts and are attracted in different situations. Excise duty is essentially a duty on manufacture of goods. And the taxable event is the manufacture of the accessible goods. Countervailing duty, on the other hand, is imposed when accessible articles are imported into the state. In order to counterbalance the excise duty, which is leviable on similar goods, if manufactured within the state. So far as countervailing duty is concerned, the incidence of the impost is on the import of the accessible articles, that is at the time of entry into the state. Section 27 of the Bihar and Odisha Excise Act deals with the powers of the state to impose duty on import, export, transport and manufacture. This section is the charging section both for excise duty as well as countervailing duty. Section 28 of the Act, on the other hand, provides for the ways for levying the duty which can be imposed under Section 27. Section 28 deals with the manner of levying duty imposable under Section 27 of the Act in different manners. Though countervailing duty or excise duty is required to be assessed and collected as soon as the taxable event arises, a facility for postponement of collection of excise duty is envisaged under Section 28 in case of sale of the accessible article from the bonded warehouse after its import into the state. While the expression levy may include both the process of taxation as well as the determination of the amount of tax or duty, the expression collection refers to actual collection of the payable duty or the tax, as the case may be. Since the taxable event for attracting excise duty or countervailing duty is the manufacture or import of accessible goods into the state, the charge of incidence of duty stands attracted as soon as the taxable event takes place, and the facility of postponement of collection of duty under the Act or the rules framed thereunder can in no way affect the incidence of the duty on the imported goods. So, note to say that notes that goods were destroyed subsequently or they could not sell it, but it is of no consequence. They, being the importer of the goods, are liable to pay and they have already paid in advance as per the rules the notes countervailing duty immediately when the goods notes were imported, because they had manufacturing facilities outside the state and they are not the manufacturer from within the state, and therefore they were liable to pay countervailing duty on import of the goods. And the next judgment at page number 22 is Mohan Mekin's case. the moment making notes matter, not kindly see at page 22, notes, the other judgment. It starts from page 22, 1976, volume 3, SEC, page 421. There are two paragraphs, note, which are relevant, note. I will not tax the lordship note for the note to the entire judgment. Two paragraph 8 and paragraph 11. Paragraph 8 note to show that the lord's statute under consideration note was similar.
Para 8.
Yes, notes. Section 3.6b is not equivalent to our notes section 2.6a. Section 31 note and 32 note is parametria with note about section 27 and 28. Then notes would come to paragraph 11.
Yes.
The contention advanced on behalf of the contention advanced on behalf of appellant, which seems to proceed on the assumption that the Chandigarh administration can impose duty only if liquor is consumed in its territory, is erroneous. As according to section 31 of the Act, read with the aforesaid entry 51 of list 2 of the 7th schedule of the Constitution, countervailing duty can be imposed on liquor made for consumption, which is manufactured or produced elsewhere in India. It is immaterial whether the liquor for which permits were obtained was consumed within the Union Territory of Chandigarh or was in existence in that territory or not. But here it has gone even more further by saying that when the moment not the goods left from Uttar Pradesh where the distilleries were there, not liability arose. What is material is whether permits were obtained for import from Uttar Pradesh of alcoholic liquor meant for human consumption and the quantity shown in the permits left Uttar Pradesh. In the present case, the liquor for which permits were obtained by the appellant was admittedly in existence and was meant for human consumption and did leave the appellant's distilleries in Uttar Pradesh for being transported to its warehouse in Chandigarh at its own risk and responsibility. It is also not denied on behalf of the appellant that a portion of the liquor which exceeded the permissible limit of the wastage did not reach the appellant's warehouse and was not found therein, and the shortage remained unaccounted for. It is thus evident that duty is not sought to be charged on an excusable article which was not in existence as contended on behalf of the appellant, but is sought to be charged on liquor which was actually manufactured in Uttar Pradesh, but was found short beyond the permissible limit and no reasonable explanation was rendered. So what is not has been said here is that the moment not the permit is obtained and the goods not is from the outside the state, not it leaves that state, then the not liability arises because you are importing it, and the moment not it enters, not liability arises whether it is actually consumed or whether it is actually destroyed or whether it is sold or not. Another judgment, not Shroff case, not is not very elaborately deals with it. Further, it has taken into consideration Patnaik's judgment also. This is at page notes 30 of the compilation. The written submissions not given by us. 1989 Supplementary 1, Supreme Court cases 347. There also not the parameter provisions were under consideration, not excise duty and countervailing duty. The relevant paragraphs would find in paragraph 2, 4, 6 and 16. The provisions have been quoted. Announcement directly come to paragraph 16.
Yes.
division bench disagreed, it has to be emphasized that Rule 2 of the octroi rule deals with the definition of various terms, and the expression import under Rule 2.2 means conveying of an article liable to octroi under the Greater Bombay from any other area outside Greater Bombay. Rule 2.5 defines duty of date of import, which means the date on which the octroi is paid, and the event of non-payment of octroi at the time of import on account of any inadvertence, error, or misunderstanding, it shall mean the date on which the articles are cleared from the place of import. Question is, when the liability to pay countervailing duty was incurred by the importers of liquor. We have noticed entry 51 of list 2 and also section 105 of the Prohibition Act. Excise duty is in essence a tax on manufacture or production of goods, and excise duty can be levied only on such goods as are manufactured or produced within the state. The countervailing duty, on the other hand, is imposed for the purpose of setting off or compensating some other duty so as to place the home producer on an equal footing with the importer of foreign goods. The essence of countervailing duty is to set off the effect of non-payment of tax on manufacture. It is meant to protect the indigenous production. This is a concept note. Then kindly come to notes paragraph 29 of this judgment. The question that arises is that the division bench was right in the facts and circumstances of the case. We have noted the relevant provisions of entry 51 of list 2 of the 7th schedule in Mohan Makings note. We have same Mohan Makings note 1976 case note has been referred to, where it was held that the contentions advanced on behalf of the appellant will seem to proceed on the assumption that the Chandigarh administration could impose duty only if liquor was consumed in its territory was erroneous according to section 31 of the Act, read with the aforesaid entry 51 of list 2 of the 7th schedule of the Constitution, countervailing duty would be imposed on liquor meant for consumption, which was manufactured or produced elsewhere in India. It is immaterial whether the liquor for which permits were obtained was consumed within the Union Territory of Chandigarh or was in existence in that territory or not. What is material is whether permits were obtained for import from Uttar Pradesh of alcoholic liquor meant for human consumption. This position stands confirmed by the observation of this court in so and so the Sea Customs Act and Section 3 of the Central Excise and Sales Act. Therefore, bringing goods into Greater Bombay with intention to use and not in transit, in our opinion, was decisive, and any imposition on that would form part of the duty which could be imposed at the time of the entry and could be included in the octroi. However, for goods in transit, Section 194A of the Bombay Municipal Act provides an exemption in accordance with the octroi rules frame. In Section 195 it will say that refund is provided for in relation to articles which are exported from Greater Bombay after having paid octroi. Immediate exportation makes it inapplicable for imposition of tax on goods in transit. That problem does not arise in respect of importation into Greater Bombay. Section 105 of the Bombay Prohibition Act, which has been set out here in above read with Section 214, 220 and 330, makes the position clear, beyond doubt, that a taxable event in the case of excise duty would be manufacture or production, and in the case of countervailing duty, import within the state. Section 106 of the Bombay Prohibition Act is headed Manners of levying excise duty. This clearly envisages administrative convenience for the point of levy in the sense of collection. The charge or incidence correlated to the taxable event is on entry into the state by way of import. The rate applicable would normally be the rate prevailing at that time. However, a specific provision is made to get over this normal position by the provisor. Then, Lord, the concurring judgment also has concluded on paragraph 41, my Lord should kindly see, Justice Ranganathan, Lords, who gave his concurring views.
Yes.
It's there in paragraph 41, which not further sums up the entire issue. In the light of these provisions, my Lords, have the page?
Yes.
In the light of these provisions, two issues arise for consideration. The first is the point of time at which the liability to pay countervailing duty arises. On this, the appellant's argument is that, in principle, this liability is not attracted merely by the entry of goods at or their removal from the customs barrier of the concerned territory, but arises only at the point of time when those goods enter the market for purpose of use, sale or consumption and mixed with other goods. It is said that this is why Section 105 is general. Section 106 clearly lays down that the countervailing duty is payable only as and when the goods are removed from the bonded warehouse for such purpose and not earlier. I agree with my learned brother's conclusion that this argument cannot be accepted. Language of Section 105, which imposes the charge, of Section 106, which talks of payment, and of the rules, leaves no doubt that the duty is attracted at the point of import, that is, physical entry of the goods into the taxing territory, and that only the payment of duty is deferred in case the goods imported are removed to a bonded warehouse to a later point of time for purposes of convenience of collection. It will not be appropriate to construe the provisions in such a manner as imposing a liability on some persons who have no bonded warehouse at one point of time and on others at a different point of time. Also, if as urged the liability to pay the duty itself were referable to a later point of time, the insistence on a bond in the terms prescribed would appear to be redundant. The provision that where the facility is availed of, the SSC would pay duty at the rate prevalent at the later point of time, often higher than at the point of import but not necessarily so, is not inconsistent with the above concept but is rather a logical consequence of the privilege of deferment given to the SSC. So, collection, quantification, and not subsequent payment on the consumption or modes sale in market with other not mixing of other goods, or its destruction, or it becoming not unusable, unfit for consumption, has no relevance at all. So far as the incidence of not duty of countervailing duty is not seen, which arises not immediately on the import. The moment it not reaches not the territory of Jharkhand, the countervailing duty, not the rule says that you have to pay this duty in advance. Now, therefore, I will take your lordship now to the relevant rules, because they have not taken that I am not the importer, I am merely importing it on behalf of the wholesaler. That is not correct. It's not the correct position, Lord, to say that, because they are the distributor. They got a pass for import of this particular goods under Section 12, read with note Form 19C and the other provisions, notes Rule 7 of the note rules, by payment of advance countervailing duty. I'm not kindly take my submissions on this, that not this is a rule which says that not he has to be a distributor and he has to be not a manufacturer within the state, and he has to be a manufacturer having its facilities outside the state. Here the conditions not for him to become a distributor. Then he applies for a distributing license. Then the law says he has to acquire a distributor's license under Form 19C, and he can sell it only to a wholesaler. And he can only import on payment of advance countervailing duty, and then only lots he can import. He can import, pays the countervailing duty, import, place it wherever he likes, in his own warehouse or wherever, and then what he has to give it and sell it only to the wholesaler. Now he has an arrangement with the wholesaler and an agreement with the wholesaler that he will import and he will give it to the wholesaler. Wholesaler will distribute in the market. That is totally not relevant at all, because that is what he does. I will not thereafter not take your lordship. Kindly come to Rule 7.
Their line of argument is that the entry into the territorial jurisdiction of the state is not the incidence of the taxation, because it is only upon clearance from the warehouse when the actual rate of tax, etc., is computed and the importer is asked to pay that. That is the taxable event.
Yes.
And there they have drawn analogy from judgments under the Customs Act, like Kiran Bala and all. Now, if
that note will not apply,
that may not apply, but we need to compare the provisions of the Customs Act with the relevant provisions of the Excise Act of the state of Jharkhand, and find out that whether the whole scheme of the act and the relevant provisions are pari materia to each other to import that reasoning in countervailing duty also.
It cannot be. As my lords have seen, not in Mohan Mekin's case and Shroff's case, which are the recent judgments, and not in a note's current judgment of 2022, Lord, I will be referring to, Lord, where not the past judgments have been followed, where the concept of countervailing duty is entirely different. And the same provision of Note Section 27 was interpreted by the Supreme Court in S.K. Patnaik case, but which still holds the field because it has been followed in Mohan Mekin's, it has been followed in Shroff's case. Same notes, not parameteria, not the statutes and provisions, not of Uttar Pradesh, Chandigarh, and not Maharashtra was considered. Where not the duty, section 27 has been held to be not the incidence, 28 is held to be the ways of collection, which can be at a later point of time, or even the rate can be different. That in no way not demolishes the incidence part. So incidence not is arising immediately when it not is imported. Now, therefore, kindly come to other provisions of the rules, which will make it more further clear that they have to pay this, and this incidence is not in any way connected with the later point of time of sale or collection. Here, the collection is also not in advance. What to say of some other point of time? Kindly come to page 11 of the compilation. My lord, have seen that section 12 says that a person can import, a distributor can import only upon a pass.
Yes.
Now this note, rule 7 note of the import note, should find note import, export and transport note heading. I have given this extract of the rules. The import, export and transport respectively of the accessible articles hereinafter specified shall be subject to the following rules. In addition to the restrictions imposed by section 9, 10 and 12 and any prohibition made under section 11 and any rules made by the board under subsection 12 or section 90 of the Act.
Yes.
Then we also come to the next page. This was a notification note by which under section S, rule 7 it was issued, and उपयुक्त विषय विभागीय पंत्रांग 1603-396 के क्रम में मुझे यह कहना है कि प्रपत्र 19C में वितरकता की नई अनुज्ञप्ति स्वीकृत करने से संबंधित कतिपय दिशा निर्देश की अपेक्षा स्थानीय पदाधिकारियों द्वारा की गई इसी क्रम में दिशा निर्देश दिए जा रहे हैं। प्रपत्र 19C में one and three. Pardon? We'll come to three.
Rules are of which year?
So this is of notes 1996, notes subsequent to 1996. 25th March 1996. These note rule 7 note says something, and then this notification was issued not for clarification in 1996.
No, I'm talking about the year of the rule.
Year of the rule. Rule notes are. It is not rules under the Bihar Excise Act 1950. It is of the year 1919.
1919.
1919. And different notifications would have been issued from time to time.
Yes.
These rules. Prapatra 19C में I am at page 12 note of the compilation.
Yes, yes.
प्रपत्र 19C में वितरक की अनुज्ञप्ति केवल आसवनी निर्माता एवं बोटलर्स धार्य करेंगे। यह अनुज्ञप्ति निर्माता आसवनी कंपनी से भिन्न अन्य किसी व्यक्ति को नहीं दी जाएगी। Not who is not a manufacturer. Then kindly see note third. राजस्व परिषद अधिसूचना संख्या 30 मई 94 के द्वारा प्रपत्र 19B में संशोधन के फलस्वरूप दिनांक 1/4/96 से प्रपत्र 19B के अनुज्ञाधारी राज्य के बाहर अवस्थित निर्माणशाला से आयात के लिए अनुमत नहीं होंगे। इसके लिए उन्हें आयात पारक नहीं दिया जाएगा। आयात पारक नोटिस इम्पोर्ट पास नहीं दिया जाएगा। दिनांक 1/4/96 के बाद राज्य के बाहर अवस्थित निर्माताओं से केवल प्रपत्र 19C में उनके द्वारा धारित वितरकता की अनुज्ञप्ति के माध्यम से ही कर भुगते पारक के आधार पर अपने निर्मित ब्रांड को ही आयात किया जा सकेगा। स्पेसिफिकली सेज कर भुगते पारक, टैक्स पेड इंपोर्ट पास। और भी पढ़ना है। Then 4 note puts a condition that वितरक की अनुज्ञप्ति के लिए दायता इस प्रकार होगी।
What happened? Yes.
4 note says वितरक की अनुज्ञप्ति के लिए दायता इस प्रकार होगी। Lord, for the distributor, the conditions are given, Lord, that he should have, Lord, a manufacturing facility. Then notes kindly come to Rule 8A. Can we come to page 14, Lords?
Yes.
Import, Rule 8, capital A. Import of India-made foreign liquor in any quantity from any distillery, brewery by any person. Sale of such liquor to the holders of sale or sale to trade. Not sale to trade, not is the wholesaler.
Yes.
Sale to trade license and to holders of license for troops and military bodies is permitted only in import passes granted by the collector of the districts of import on prepayment of duty.
Yes.
As well as any import pass fee prescribed by the Board of Revenue under the Treasury into the Treasury for importing district, provided the conditions specified in Rule 8 are mutandis satisfied. So, more conditions are that he has to be manufacturer, he has to be importing, he has to have a distributor's license, and he can sell only to a sale to trade. That is not he can after not import, he can sell it only to the wholesaler, and then he can import only upon prepayment of the duty. Not that not he has to give the pay the countervailing duty at some later point of time.
So, a person who has got an import pass has to prepay the duty.
Prepay the duty.
And the moment the goods leave the state of manufacture or the origin state of manufacture, the liability to or the taxable event arises for countervailing.
Yes.
Whether it crosses the territorial boundary of the state where the tax is being realized is immaterial.
Material, or even at the base note when it enters the note's territory, import.
No.
Moment note it is on import itself. Import can be at to once I obtain the distributor's license, pay the countervailing duty, and not the goods start from the warehouse from my distilleries outside the state. The liability arises.
That is what we are saying, that
Yes, yes.
in the judgment of Justice Radhakrishnan,
Yes.
and other judgments, the moment
Exactly of the same.
it has left the state of UP,
Yes.
check
On,
that
on an import
Chhattisgarh
on an import license or an import
on an import license.
permit, then the liability arises. Whether it is
And,
actually
and
consumed
in
or
your
not,
case, the movement or the import pass itself is given on prepayment of duty.
prepayment.
So the taxable event arises the moment the goods, the person obtains an import pass to bring such liquor, foreign liquor from outside state.
From outside the state. On prepayment.
Reaching the warehouse or getting cleared from the warehouse is
not material goods, not relevant for our
any
case at all.
relevance.
It has no
Not
relevance at
any
all. Not relevant. Or actual consumption or actual sale of the goods note has no relevance. That is what Lord S.K. Patnaik, Mohan making in Shroff's note in unequivocal terms note have reiterated and has not they have explained. Because there is a difference of payment of accessible goods and payment on not countervailing duty. Excise duty is on actual manufacture.
Then why is there a condition that in case on the date of clearance from the warehouse, if there is a increase in tax, the same will have to be paid?
So this is not particularly taken care of not in the Shroff's case at paragraph 41. The same position that even the rates note may vary at some later point of time on increase or decrease note. It says the provision that where the facility is availed of, the SSC would pay duty at the rate prevalent at the later point of time, often higher than the point of import, but not necessarily so. Is not inconsistent with the above concept, but is rather a logical consequence of the privilege of deferment given to the SSC.
No, the deferment doesn't take place.
Here there is no deferment.
There is no deferment. Here is a
I am paying in advance.
Not he is paying in advance, but not suppose not the duty not actually not is increased, rate is not increased later on. So that is not any not if he actually sells it, that is at a different later point of time. That is not a different concept. Not here not he actually pays it.
No, so
Prepayment.
why should an importer or a person bringing the foreign liquor from outside state subject to the prepayment of tax or countervailing duty be again liable to pay the variation in the tax?
No, he is not liable to pay here. There is only a provision that it may happen. But here the provision, not we have
has to
made
be
that you have
backed
to
by a
pay.
principle.
The
There is a provision.
28. Notes is referring to section 28 probably notes.
Yes, yes. Section 28
28.
proviso, second proviso.
28 notes proviso and 28 note in two terms note. Section 28, I will come to 28 again. It says either it can be prepaid or it can be at a later point of time or at a different rate. Both note conditions can be imposed by the state.
No, both conditions. State is the rule-making authority, so it can impose all kinds of conditions, but which is supportable by a legal reasoning or a legal principle.
Yes.
If on a later point of time at the stage of clearance also you make him liable to pay the difference.
I'm not here. I'm not making him liable. Here, there are two provisions, which gives us, which enables the state to prescribe whether I can take a prepayment or I can take payment at the time of collection, which can be at a later point of time from the dispatch from warehouse or at this time of sale in the market. Here, I have chosen the first part of prepayment. I'm not taking him again to the later point of time.
So, is
even
it
if
your
at a later point of time, this Supreme Court says the incidence arises.
Maybe, but in your case, is it your stand that the variable tax would not be a liability for the importer to pay after the prepayment has been done at the time of making import pass?
It is either or. I will come to the section 28 notes would see that. It is either or. Section 28 note can kindly see section 28. Can we come to section 28 notes?
Yes.
On an accessible article imported, note I am reading 28A,
Yes.
28.1, note Roman A. On an accessible article imported by payment upon or before importation, which is not the case here, in the state or in the state of territory from which the article is brought, or by payment upon issue for sale from a warehouse established, authorized or continued under this act. Both cannot happen.
No. What is happening that we want to know? The
Or not
language
prepayment.
of
What is happening, I am showing note. What is happening, I am showing. It is prepayment which is happening.
So he is not liable to pay any difference in tax at the time of clearance.
Note, kindly say I will come to the import pass notes where not he is the consigner and the consignee note he is already prepaid. I will not come to that.
No, actually what is happening on that, your officers may give you
Lord, we can take a clear picture, Lord, but as per my understanding of the law, Lord, as it is reflected in section 27 and 28, these two are different things, not either an or not position. If I take a prepayment, or I can take it at the point when he dispatches the goods from the warehouse. The rules say that he has to prepay before he imports. Kindly come to Lord page 15 of the Lord's compilation. Form 19C, I have shown note rule 8A also which says the prepayment. And note form 9C note which is the distributor's license that they have to obtain. Also puts a condition. Page 15.
Page 15.
It is form 19C note. Clause 2 of the notes form. कि वह थोक बिक्री सेल टू दी ट्रेड के अनुज्ञाधारी या कि वह थोक बिक्री सेल टू दी ट्रेड थोक बिक्री नॉट द होलसेलर की अनुज्ञाधारी उत्पाद प्रपत्र संख्या 1 के अनुज्ञाधारक तथा फौज और सैनिक निकायों को छोड़कर अन्य किसी अनुज्ञप्ति विक्रेता को विदेशी शराब नहीं बेचेगा. Those who take form 19C. Then 8 clause 8 कि वह अन्य राज्यों से विदेशी शराब के आयात के लिए समाहर्ता अथवा उनके द्वारा प्राधिकृत किसी अन्य पदाधिकारी से कर और आयात पारक शुल्क के पूर्व भुगतान पर आयात पारक प्राप्त करेगा तथा आयातित विदेशी शराब के पहुंचने के तुरंत बाद ही उसकी सूचना स्वयं को दी जाएगी. He has to पूर्व भुगतान पर आयात पारक शुल्क मिलेगा, उसको आयात पारक पास मिलेगा.
If that is your stand, then the whole line of argument of the petitioners
They kindly see page 17 notes. Kindly see the page 17 note, which is the actual facts note of the case. Kindly see page 17. Their distribution license that they have obtained, Carlsberg. Import pass, page 17.
Yes.
Pass for the import from the province of foreign country spice liquor made in India or rectified spirit on which duty has been paid. To whom the permit is issued, Mrs. Carlsberg, India. Name and address of the consigner, again it is Carlsberg, Himachal Pradesh. Consignee, again it is Carlsberg. Total duty deposited note, serial number 5. Is the total duty which has been paid, treasury challan, everything note they have paid. And then they have obtained the distributor's license. Now I have not pause here for a moment for an alternative argument. But let us say this was not a prepayment. They only had taken the distributor's license without any payment. Then they were liable to pay under 28B at the time of dispatch from the warehouse or actually sold. That was a later point of time of collection, which the Supreme Court says that the collection can be deferred, will not absolve them from the liability because the incidence arises the moment they import the note goods. And here, not actually, it is a prepayment aspect. They have taken the license on prepayment. The two paragraphs notes of the recent judgment of the Supreme Court, 2022, have you sent it from yesterday? Yesterday night. But yesterday night notes at 11 p.m. Lords, my friend Lord Salona Lord has sent it. Probably whether I've not, my lords have got that not judgment or not.
No, we have not got that, or maybe
It is not a state of UP versus notes. State of UP versus McDowell and Company. 2022 Supreme Court cases online. Supreme Court page 15.
2022.
SEC online Supreme Court.
Yes.
S15.
15.
15.
What does it say?
It note has also not considered note the. Can you present it? Because my friend is presenting it notes, two paragraphs, paragraph 54 and 64. We will be presenting. We can present it not here, notes. I am presenting it.
There also in COVID, the beer could not be sold.
It could not be notes. But it is being presented notes.
Size has to be.
Yes. Come to paragraph 54 first.
Size has to be increased.
You can increase the size. थोड़ा कम करो, ज़्यादा हो गया, कट रहा है. कम करो.
Yes, yes.
This is enough. Come to paragraph 54 first.
54.
4 minutes. 54.
Yes.
The parameter provisions just do not show the sections which have been quoted.
Yes. आया नहीं है मुझे ना पीछे
उसको नीचे ऊपर करो. Para 54 minutes would see not the same notes provisions, not parameter provisions are there. Kindly come to then paragraph 64. Come to paragraph 64. We'll see to show the relevant paragraph.
Yes.
As per section 19, no intoxicant, and that obviously includes the liquor manufactured by the respondent, can be removed from the distillery or the place of storage unless the duty leviable thereupon has been paid or a bond has been executed for the payment thereof. Considering the overall scheme of the Act and the rules, it may not be out of place to interpret the expression removal. Not here was the payment of excise duty, and whether or not removal or actual consumption was the consideration. It may not be out of place to interpret the expression removal in section 19 to include wastage in excess of permissible limit of total quantity of spirit produced or manufactured and stored. A comprehensive look at the scheme of section 17 to 19 and 28 to 29 of the Act of 1910 and the enunciations of this court leave nothing to doubt that in respect of the liquor that had undergone the process of distillation, accessibility to excise duty had occurred at the end of the distillation process or when it was issued from the distillery. The point of quantification of this duty, even if linked in point of time to the date of issue for sale in terms of the proviso to section 29, does not relate to the event of chargeability, and that had occurred as soon as the liquor was distilled and received in the bottling tank or had been otherwise issued from distillery. In other words, the liquor that was lying stored in the bonded warehouse had already become subject to the excise duty, with postponement of actual charging of the duty as per the rate applicable on the date and time of issue for sale from the warehouse. It gets perforce reiterated, the taxable event was production or manufacture and not the sale of the liquor.
Yes.
For the countervailing duty, it is import. Same principle, my lords. The moment not the license is taken for import and it leaves not the distillery from the place of its origin, they become notes. The incidence to charge the duty notes of countervailing duty is attracted. Now it can be not on is question under section 28. It can be on the not basis of prepayment, or it can be not some payment at some later point of time, or some not whatever note they say. But here it is a case of a prepayment. They have taken a distributor license note on prepayment of the duty, countervailing duty. And to our not submission that any at point of time, not even if it is adjusted according to note that for that note we will take note specific instruction. I don't think not as per the law not anything more note is required on that. But we still will take that instruction. But even that note would not matter. Even that would not matter because the incidence has arisen on
So
import.
that is that's the area on which the petitioners are harping.
That what Supreme Court has already clarified it. Mohan Making's case and Shroff's case particularly, and with respect to our Bihar and Odisha cited section 27, S.K. Patnaik judgment. It has clarified on that very particular point. That
This
incidence
is one part. The other part is they are seeking help from assistance from judgments rendered in case of
yes.
imports
Now,
from outside.
yes. Kindly not come to our written submissions, note which we have given note in detail. In a tabular form, their judgments and how not it is not relevant. Which page? They are not all judgments on the basis of not Customs Act or the Excise Act. We contemplate the Iran spinning mills case. Not we have not in tabular form. Not we have not given notes the distinguishing features. How that note judgment has been read in this not in case of a Customs Act or a Central Excise Act, and what there is notes. Countervailing duty note is a different concept. The incidence of countervailing duty is not very different and distinct from the excise duty or even a customs duty. None of the judgments not are on the issue of not countervailing duty. Supreme Court has very specifically given its judgment note and findings on the countervailing duty, its chargeability, incidence.
Because of this line of argument by the petitioners, you have to take instructions to clarify as to whether there is any vagueness in the taxable event, whether it also takes place at the time of issuance of import pass and at the time of clearance.
That note we will take a specific note, we will ask the department.
And
I think what it will be.
Secondly, also on the rate of tax, because at the time of issue of import pass, the rate of tax may be different, and obviously, if it is at the stage of clearance, it may vary, which the petitioner may be liable to pay. So this point.
At these 2 points, what I will take instruction. Yes.
So Mr. Gulati, we are not very clear today.
Lord, I want to point out something very clearly, Lord. Kindly just have page 41 of my compilation. I should clarify it. And what is our stand, Lord? Our stand is that we are here seeking a refund. So it is obvious that before the issuance of the product from the warehouse, Lord, we have paid the duty, some duty. What is our stand? Our stand is that that collection is merely an advance. It sits as a deposit with the state. and the actual determination of duty happens only on, my lord, the clearance from the warehouse. And kindly just have page 41 for a minute again, my lord, of my compilation. I should clarify, this is statute. No rule, no policy can get over this, my lord. This is statute. Page 41.
Yes.
Lord, kindly see where, my lord, goods are actually deposited in a warehouse. My learned friend is pointing out to your lordships the 28A 1 or 2 to say that there is a choice with the state where they can levy the duty either in advance or, my lord, at the time of issuance. But the second proviso and the first proviso says that where goods are deposited in a warehouse, it shall be the rate of duty in force on the date of issue of from such warehouse. Very clear impact that this will be the date on which you will have the impact, and this is in parameter to section 15 of the Customs Act. Then the second proviso provided further that in case of excisable articles imported or transported on payment of duty. So it is second proviso is specifically considering the fact that I have already paid the duty in advance.
Will be applicable.
Please note the circumstance. Provided further that in the case of excisable goods imported or transported on payment of duty, according to the provisions of clause 1 of clause A or clause C of this section. So, my lord, that is, if the state had exercised the power under clause 1, which is at the time of importation by payment in the state or the territory which article is brought. That is what my learned friend's case. What he's saying, that I have paid duty according to this. The difference of duty resulting from any provision in the rates of duty subsequent to such import shall be realized from or credited to the account of importing or transporting the license according to the revised rate of duty, which may be higher or lower than the previous rate, and the calculation that should be made on the balance stock of excisable article on the date of the revised rate of duty comes into effect. Therefore, my lord, what does this indicate? That it is the final rate at the time of issuance which is the relevant rate. Otherwise, there is no rate. What you have collected is in advance. Now, my lord, if I don't issue or it has become impossible to issue the product from the warehouse, the rate is zero. Then it is never.
That notes to my notes. Our submission is
one other thing, my lord, before my learned friend intervenes, my lord, that exactly, and what is our case, my lord? Cases on manufacture where the manufacture is a taxable event. Here, my lord, for countervailing duty, it is the import which is the my lord, taxable event. I think both parties are ad item on that. My lord, our case is that import is a process. It starts with the entry of the goods, but ends only on issuance, according to Garden Silk Mills. It ends only on issuance. So the taxable event itself is not complete at this stage. You may have collected something in advance, but it's a process. And that process needs to end before the duty can be finally determined. And therefore, cases of manufacture are not at all relevant because manufacture is complete. And it's only the payment which is deferred. Our case here is, it's not just the payment. The collection, my lord, is a machinery provision. The levy of tax is a substantive provision by according to which, my lord, the duty arises in the first place. And as, my lord, I have said in my opening, my lord, that Ganga Saran, Govind Saran Supreme Court judgment says there are 4 essential ingredients of a tax which need to be available for you to be able to levy the tax. And one of them, the value, the rate, the person who is liable, and the nature of the levy. Now, the nature of the levy is important. The rate has to be available, and therefore, my lord, I have cited Supreme Court judgments to say that the date on which the rate applies is when the taxable event will arise. So here we are not talking about where the taxable event was complete. We are talking of a situation where the taxable event is incomplete. Had the taxable event been complete and only a collection was deferred, my lord, I have no case. But that's not the situation here. Here the very levy is, my lord, not complete. It cannot come into play. It's a huge distinction. And to say, my lord, that the Supreme Court judgments that I have cited are not on countervailing duty is also incorrect. Why? Because, my lord, countervailing duty even in customs arises under section 3.1 and 3.3 and 3.5 of the Customs Tariff Act. And the same principles and all the provisions of the Customs Act, my lord, mutatis mutandis apply to the levy of countervailing duties under the Customs Act. And countervailing duty is only a duty equivalent to what, my lord, a domestic person pays. That's the only meaning of countervailing duty. Otherwise, in effect, it is an import duty. The levy is on import. And at that stage, my lord, the Supreme Court says that the import gets completed only once you can charge the duty. That is why, my lord, they treat the warehouse as a duty-free enclave within the country. And only once you issue it, and the, my lord, the logic is that when the goods are issued from the warehouse, they become the part of the mass of the goods of the country. They assimilate, my lord, with the goods of the country. They cease to be imported goods. Now, my lord, compared to that, in the state, this, my lord, liquor is coming from outside the state of Jharkhand. Unless there is an assimilation where it goes into the market, where, because ultimately these are all duties on, my lord, alcohol, which is meant for human consumption. From the constitutional point of view, my lord, unless it is fit for human consumption, there can be no duty at all. Unless it becomes in a marketable state, which is only on the issuance from the warehouse, my lord, there is no question of a duty. So you may have collected it in advance, some amount, but that takes the character of only an advance, nothing more than that. And if it is an advance that you are retaining, then if that final taxable event has not occurred, then am I entitled to a refund is my case, my lord.
Not taxability part, which is the incidence part, and not the collection note, which is not whether paid in advance and some part is later on collected, some notes rate at some differential rate, is a totally distinguishable, because the Supreme Court says, particularly in respect of countervailing duty, that not the incidence starts the moment it is imported. You take a license to import, you have to pay. Whether you pay at some rate in advance and some at some later point of time is not material at all, because what Mohan Mekin's case has and Shroff case has particularly clarified this, that collection of any rate is a different notes matter than the incidence of not the chargeability, not part of the import of the countervailing duty.
So we would appreciate both lines of argument, but for the present, we feel that there should be a comparative table of the parameteria provisions.
Correct notes. I think that will be very notes appropriate, because not the provisions which have been notes interpreted by the Supreme Court, our excise, Maharashtra Excise Act, are very relevant.
Odisha Patna Act is same act, 1950.
It is the same act.
Mohan Mekin,
Chandigarh and UP.
Punjab has a different act.
Same parameter provisions notes.
Andhra Pradesh has a different act.
Provisions are the same.
And the decisions on which the petitioners are relying relating to customs,
yes,
the relevant provisions of those acts also.
We'll do that. We'll make a comparative.
We will give a comparative notes. We will quote it.
Yes.
Not our notes, Bihar, UP, Chandigarh, and not the Maharashtra provisions. And let my friend also say not the customs note provisions.
Yes.
We'll do that, my lord. And my lord, I'll be at pains to show.
Is there before your lordship notes?
I'll be at pains to show, my lord, that had the proviso to section 28 been considered,
payment not
the decisions would have gone. The decisions would have gone the way the customs decisions have gone. There is no question, my lord, that if a rate is not available and if it is the final rate, then can you say that the levy is complete and the collection is postponed? That's my case, my lord. That's the short case.
No, we appreciate that, but the judgments on Excise Act, especially concerning the same 2015.
But this kind of provision has not been noticed also, not even noticed.
So that you will have to that you are trying to overcome, because in Patnak's case also these provisos were not discussed.
Not discussed. Not brought to the attention of the court.
So let us see. We have an area where
I have, my lord, cited other Supreme Court judgments, my lord, in terms of section 15 of the Customs Act, which also prescribes the date on which the tax will apply. Section 15 of the Customs Act says that there are two dates, my lord, which one, if it is import, then the date of filing of the bill of entry or the prior filing of the bill of entry. If it is warehouse, then the date of issuance from the warehouse. Same thing, my lord, that the date of rate of tax becomes material. And Supreme Court says therefore that it will be that date. And that is the time when we consider the import to be complete in case of warehouse goods. If you're not warehousing it, then clearance. Then clearance from the customs borders.
Let us see this.
But, my lord, one thing is clear, that the earlier law of the Supreme Court to say that mere entry into the borders, or, my lord, when you talk about customs, mere entry into the territorial waters of the country is irrelevant. That law, my lord, Supreme Court itself has overturned now in APAR.
No, that's true. That they say crossing of the custom barrier
means nothing.
I'm not. The recent judgment of the Supreme Court note has also taken note of the proviso. Also, Lord, we will demonstrate that.
Very well. So,
the moment not the goods are manufactured, distilled, the duty of not liability arises, even if it is
it
not
possible for Mr. Gulati to be here on a physical date?
That would be better, sir.
That would be preferable, not for me. I'm not we will invite Mr. Gulati to come here.
No, my lord, it's always a pleasure to be there. But, my lord, if your lordships can allow us the convenience of an online hearing, my lord, nothing better for us for that. If possible, my lord. If not, my lord, I'll be there. There's no problem, my lord.
Some physical day, my lords, would be preferable. Physical hearing day.
My lord, if it's possible online, my lord, I'm making a request. Otherwise, my lord, I'll come.
It's very simple now. It's live. You have to slide that particular issue. Okay.
In the coming week, we can perhaps keep it on 19th. That's Tuesday. Or else we may have to go.
Yes. 19th is okay.
19th, my lord, is fine by me also.
19th, this comparative table, etc., would be ready for our consumption.
I will make it ready, notes. No difficulty with me.
Let it keep on 19th. Let us see.
All right, Lord.
Would it be online or would it be physical?
No, 19th is a physical day, Mr. Gulati.
Probably from the next week, all days will be physical hearing day.
Oh, is it?
Honorable Chief Justice note was not commenting.
Okay.
But my friend here who's briefing me, my lord, has some problem for 19th on the physical. Is it possible for your lordship to, my lord, then take it in the...
We can then keep it on in the next week thereafter.
29th, my lord, Friday, is it possible for your lordship?
No, Friday we are sitting singly. So we
Friday is closed also. 29th is not a holiday in India.
Yes.
29th is a holiday also.
And even otherwise, it's a different bench.
We can keep it on 28th April at Thais.
My lord, I have a part-heard matter in my lord, the court on 29th. It's already part-heard, my lord.
28 perhaps.
28 my lord, then is it possible to keep it on 3rd, my lord, 3rd of May?
3rd again is a holiday for us.
3rd again is a holiday for Eid.
Lords, may keep it on 4th, 10th, Lord.
4th, we can keep it.
4th or 5th. 5th, Lord, is not if it is preferable.
4th would be okay. 4th we can keep.
4th.
4th May.
4th.
What's your
4th.
4th.
4th May is Wednesday. So if it is a virtual day, then of course you will have the benefit.
Thank you. I'm deeply obliged for that. If it is a virtual, my lord, if my learned AG is saying, my lord, that everything will go physical, then of course, my lord, there is no option.
Now let us see what happens. Learned. Please send your appearances, junior counsels. Learned Advocate
Yes,
General advanced his submissions. for further submissions on behalf of the state and the petitioner in reply, and reply on behalf of the petitioner is the case on 4th May 2022 as prayed for.
I'll send the appearances.
Very good.
We sent it last time also, Milord, but somehow, Milord, it is being missed out. Milord, Mr. Pri, if your lordship could allow, Milord, this to be dictated. Milord, Mr.
No, you
Pri.
send it, it will be done. Send it through the court master.
Yes, much obliged.
Very well, brother.
Okay.
Thank you.